Good morning, and welcome to day 2 of our CLE event. If you were with us yesterday, thanks for coming back. And if you're joining us for the first time, welcome aboard. A few housekeeping items to note this morning. All materials will be downloadable from the website, and you will get an email from Kelly about how to do that. If you've provided your Ohio, Florida, Illinois, New York attorney registration number or your CPA number, you will receive credit. No further actions needed. If you've not provided it, just email Kelly and we'll take care of it. It's important. We're going to email a post-event survey. A couple reasons this is important. Number one, we use this as your attestation you actually attended. So to get your credits, you do need to complete that. Equally important is we use that information to improve what we do and bring you the speakers that you'd like to hear each year. It's hard to believe this is our 33rd year doing this. And as in the past, we do review that. And then, as with yesterday's speaker, who was requested last year, we will use your information to build next year's event. If you have questions, you can chat them with the chat function, and we will generally address them at the end of each presentation. If you think of questions afterwards, feel free to email me, and I can connect you with the speakers, get you the answer, or just make something up, as it depends. The email for myself is randy.carver@raymondjames.com. So, one of the biggest things that I think we've seen this year as the result of the pandemic is a bigger pivot to digital by companies. A lot of companies moved to what Kevin O'Leary termed USA 2.0. An interview, if you haven't seen it, it's on our website. But as more companies have pivoted to more digital interactions during the pandemic, the acquisition and management of our personal information in online environments is really becoming ubiquitous, as are data breaches. And in the aftermath of the massive data breaches that have really impacted hundreds of millions of consumers, states are looking at ways to pass more robust data privacy and cybersecurity laws. Moreover, companies and your clients may be concerned, A, that the laws go too far, or that they're not following what they need to do, resulting in potential liability. Clearly, consumers are concerned that the laws don't go far enough. In our business, one of the questions we hear constantly is how secure is our information? And some believe there's not adequate compensation in the event of a breach or privacy violation. So today, we're very lucky to have one of the foremost experts in the country to discuss, as our course will look at the current legal landscape of data and privacy laws in the United States, as well as some new things that could set precedent and things that your clients should be looking for. We're very lucky to have Amy Keller. Amy is a partner in DiCello Levitt Gutzler, one of the co-sponsors of today's event, and has built a national reputation directing litigation and nationwide class action issues centered primarily around data and data breaches. She's the firm's technology practice chair. She's also the youngest woman ever appointed to serve as co-lead class counsel in a nationwide class action. Amy's an elected member of the American Law Institute, recognized by Illinois super lawyers as a rising star, as a board member and executive committee member of the Public Justice, a not-for-profit legal advocacy organization. Amy's a member of the Sedona Conference's Working Group 11, which focuses on litigation issues surrounding technology, privacy, AI, it's artificial intelligence, data security, and serves on the Cybersecurity and Privacy Ethical Advisory Board for Law 360. Amy's been recognized as a National Law Journal plaintiff trailblazer elite woman of the trial bar by AIM, and one of the top 40 under 40 trial lawyers in Illinois by the National Trial Lawyers Association. She's also on the production team and is a writer for the Chicago Bar Association's annual bar show, now in its 98th year. Amy went to the John Marshall Law School, once at Cleveland Marshall, at the University of Michigan, and was the administrative editor for the John Marshall Law Review. With that, it's truly my pleasure to bring you Amy Keller.
Thank you so much, Randy, for that lovely introduction. I hope everyone is doing well this morning. I'm here to talk to you today about something that is on the minds of many consumers as well as companies and corporations, and that is data security and privacy. A lot of people have been asking me, especially over the past several months because of the pandemic, what can I be doing as a company or as a member of a corporation to comply with various laws that have been passed, especially because I'm collecting so much consumer data, given that everyone is working from home and that people are shopping from home more often. And I'm also getting a lot of questions from consumers about what they can do to better protect themselves when they're interacting with entities and companies online, given our new environment. As you can see, or maybe you can't tell, I'm actually working from home right now, and we're all in sort of this interesting state where we're trying to adapt our technologies to allow us to have some flexibility so we can continue working and we continue living our lives. As a result of that, there's been increased activity with regard to cyber crimes. A lot of malicious actors out there are trying to scrape data from the internet, and as well as the dark web, which is the internet you can't see, to commit more crimes using consumer information. So there's a lot going on right now in the data security and privacy sphere, and we're going to scratch the surface really on some of those issues as it pertains to holding companies accountable, and also what companies should be concerned about as they are engaging with consumers in a more online way. So I've entitled this Privacy and Data Security in the United States, When the Law Tries to Play Catch Up. As we'll talk about later on in this presentation, a lot of the tools that consumers use to hold corporations and entities responsible when there is a data breach or a privacy violation are outmoded and outdated. We actually, when bringing data breach litigation, rely upon Section 5 of the FTC Act, which is very old and was passed not contemplating data breaches, actually. So when we look to a lot of the work that I do on the side of consumers in this space, we're actually relying upon very old legal principles and laws to try to hold companies accountable. So in this presentation, we're going to look at a few things. First of all, we're going to look at litigating data breach cases. There's a couple of legal principles that you should be aware of when it comes to litigation in the data breach sphere. First of all, we're going to talk about standing. That is, what do I have a case or controversy that will allow me to bring a case to the courts? Then we'll look at damages. What are consumers entitled to when there has been a data breach? Post-breach investigations. This is a very, very hot topic right now in the courts. This is basically what entities do after a data breach to figure out how the breach occurred, and whether or not those investigations are protected as attorney work product or as attorney-client privileged. Then we'll look at settlement. A lot of these data breach cases, in fact, no data breach cases have gone to trial. Usually what will happen is they will be litigated for some time and then eventually settle after you reach a couple of landmarks throughout the litigation. So we'll talk about what settlements typically look like and what people should take into account when negotiating a settlement. After that, we'll look at the legal landscape. So what is being done to update the laws, because I've talked about how outmoded and outdated they are. We'll talk about data breach notification statutes, which have been passed by all 50 states. Basically, what consumers need to know in the event of a data breach. Then we'll talk about the California Consumer Privacy Act, which has now transitioned over to the California Privacy Rights Act, pursuant to the recent election. Then we'll go on to the Illinois Biometric Information Privacy Act, and we'll have a little bit of a preview about what will come next down the pipeline for some of these other laws that we're seeing. So on to litigating the case. As I promised, we'll talk about standing first. So data breaches happen each and every single day, impacting hundreds of millions of people per year. And in spite of all of that, consumers still have an incredibly difficult time holding companies accountable for being negligent with their data. So why is that? Well, because there's a lot of things that consumers have to accomplish in the court system in order to hold companies accountable. And people are frustrated. You've likely been a victim of data breaches yourself, or on the other hand, you might have been working for an entity who had a data breach. So we're going to look at basically these competing interests and what happens in litigation after a data breach occurs or after a privacy violation occurs. And you'll hear throughout this presentation, I'll refer to data breaches and privacy violations as kind of one and the same. And that's because they're two sides of the same coin. On one hand, consumers have an entitlement to keep their information private and to only disclose that which they want to disclose or which they've given permission to disclose. And then on the other side of the coin, you have data security. So that's basically once you've established this agreement about what is private and what is public, how can you ensure that you keep that information private? How can you ensure that sensitive financial information is not disclosed, which we all would agree should be kept incredibly private. In the event there's a violation of that, consumers have some options. And typically, the best option available to consumers would be to bring a lawsuit in court. They could bring it in state court or they can bring it in federal court. Typically, these data breach lawsuits are brought in federal court because you're dealing with nationwide data breaches that cross state lines, that impact consumers from each and every single state. Now, if those kinds of data breaches happen and you have a nationwide scope, then typically the case will be litigated in federal court because of something called the Class Action Fairness Act. And that's basically if you have damages that might be over $5 million and you have your plaintiffs, your consumers, are people that live in different states than where the defendant is located. So if we're suing in federal court, we have to satisfy something called standing. And that's pursuant to Article 3 of the Constitution, wherein you have to demonstrate that you have a case or controversy that the courts need to hear. It's a threshold issue that has to be determined at the beginning of the case, and it determines whether or not the court has something called subject matter jurisdiction to hear a dispute. Now, I'm going to be using like a lot of legal jargon, and that's because when entities have a data breach, they have to be thinking about these kinds of things, because if it turns out that consumers don't have standing to bring a lawsuit, then the lawsuit gets dismissed. And there's no more way to hold companies accountable in the federal courts aside from your other enforcement mechanisms, for example, like states' attorneys general, the Federal Trade Commission, and other entities that would likely pursue companies for statutory penalties. So let's get back to standing. To have standing, the consumers have to show that they've suffered an injury in fact, that it's fairly traceable to the data breach and to the conduct of the defendant, and it's likely to be redressed by favorable judicial decision. This is a concept that has been in the courts for quite some time now. There's a case called Lujuan versus Defenders of the Wildlife. That was a Supreme Court case from 1992. And more recently, the Supreme Court looked at this case called Spokio versus Robbins back in 2016, where Mr. Robbins complained that Spokio had actually published inaccurate information about him online. Now, a lot of people laughed because the information about Mr. Robbins was actually more favorable than in real life. They had, for example, said he had a job that he didn't have, that he was married, that he had more stability maybe than he had before. So the defendants and the business community, they were kind of laughing, like, why would you bring this lawsuit if Spokio was making Mr. Robbins look better? And the plaintiffs in that case said, well, a company may not hire him because, they may think that he's okay and he doesn't need a job. Very interesting legal theory. Not sure I would have brought the case myself, but here we are. So the Supreme Court in that case basically reaffirmed that to bring a lawsuit, you have to show that your injury and your damages are traceable to whatever the defendant did that was wrong. And then as a result of all of this litigation, the courts now look to standing to answer this big question. Do you have to show as a plaintiff that a data breach caused some kind of misuse of your data in order to bring your case? So that is, what if a plaintiff was involved in a data breach and their data was exposed and maybe their data is available on the dark web? Is there any harm or foul if their data is never purchased by a malicious actor, or if their data is never misused? Because data breaches happen so often, does it really matter if the data is out there and the consumer or the plaintiff never has an issue, or their information is never used to make fraudulent purchases, to open an account not in their name? This is a threshold question that a lot of courts are grappling with. So here's what happened, what's been happening in the courts. The case law seems to suggest that the plaintiffs don't have to demonstrate that their data was actually misused or how. And there's a couple of cases that have come down the pipeline that talk about this. We start with Clapper. We look at what happened in that case. And in that case, the plaintiffs were afraid that the government might have intercepted their private communications. Fear alone is insufficient to demonstrate standing. Okay, so we're demonstrating some principles. We're laying the groundwork. Then we come to the Neiman Marcus case out of the Seventh Circuit. Now, in that case, so we already know that fear enough is insufficient to demonstrate standing. Fear enough is insufficient to allow me, the plaintiff, to bring a lawsuit. However, we come to Neiman Marcus and we say the increased risk of future injuries that are sufficiently imminent, right? So the increased risk that someone could take out a loan in your name, a credit card, make purchases in your name where you haven't authorized it, and the increased risk of identity theft, as well as the time and the money a consumer spent to protect against future identity theft, is sufficient to confer standing. So what's the difference? We know that fear is not enough to bring a lawsuit, but if you have a sufficiently imminent risk that something might happen, that's enough to bring a lawsuit. What's the difference? Well, a lot of courts are still grappling with this. And then that's why these circuit courts are still considering these cases and are still taking these appeals to think about these cases. You look at the Zappos case out of the Ninth Circuit, that was in 2018. And again, we have a court thinking about why the information was taken, okay? So now we're starting to frame this out a little bit more. Hackers steal information, according to the courts, because they're going to use it for malicious purposes. Why else would you have a data breach? Okay, so now we're framing it out in the Ninth Circuit. The way the courts are moving is that plaintiffs now have to show that if the information was already used, that is a better case for the plaintiffs. That we have the Hutton case out of the Fourth Circuit, where the plaintiffs actually showed that they had fraudulent charges on their cards. And there were sufficient allegations to say that the data breach was a plausible source of the plaintiff's personal information being used to commit those fraudulent activities. In Super Value out of the Eighth Circuit, didn't reach the question ultimately about whether data misuse was necessary to confer standing, because one of the named plaintiffs had already demonstrated that they had misuse of their data. So again, the courts are kind of all over the place on this issue. But it seems like the trend is that as long as a plaintiff can say, hey, I spent time, I spent money dealing with this data breach, I'm out of pocket because of this data breach, and I would not have been but for the data breach, that is sufficient for a plaintiff to sue a company in federal court for a data breach. So that is where the courts are going. Now, the one thing that I would caution companies about is careful what you wish for. A lot of times we'll see a company argue in federal court that the plaintiffs don't have standing to bring a lawsuit because they can't demonstrate that their data was actually misused, okay? Now, sometimes federal courts have dismissed those cases, and then after those cases were dismissed, the plaintiffs refile in state court because state court's a little different. In state court, they don't have this standing requirement because we're not relying upon Article 3 of the United States Constitution to bring a lawsuit in state court. So if the plaintiffs bring a lawsuit in state court, the defendants then can't argue that the case should be heard in federal court because they've already dismissed the case from federal court. The Collier versus SP Plus Corp case, if any company is out there and is thinking about how they can best litigate a data breach case, I would encourage them and I would encourage their counsel to review that case because it basically stands for the proposition that you can't have it both ways. You can't simultaneously say the plaintiffs can't sue me in federal court because they haven't demonstrated that the data was misused, and then also go to state court and say, well, if anything, this case should be heard in federal court because of the Class Action Fairness Act. There's a tension there. So I would encourage, if there are any in-house people here today, or if there are any folks who typically represent companies on the other side of the V in data breach cases, I would encourage you to review the Collier case. There are other cases like this. There's one out of New York as well that basically caution defendants, be careful what you wish for. So now that we've figured out how a plaintiff can be in federal court to pursue damages as a result of the data breach, now we look at, okay, so what are they entitled to if they are actually victims of a data breach? And on the other side, what does a company's exposure look like if they also were victims of a data breach and a hacker stole information from the company? There's a couple of theories of damages out there. There are statutory damages. Private rights of action are being created through various statutory regimes. We'll talk about the California Consumer Privacy Act a little bit later in the presentation. And some state consumer protection laws also provide for statutory damages. And that basically allows consumers to get monetary damages, sometimes as high as like $1,000 per incident, just by virtue of being victim of a data breach. There's also the benefit of the bargain theory for contract-based claims. So if you as an entity provided a service to consumers and had a bargain for exchange and information was exchanged as well, there's a theory that consumers would have paid less for your services had they known that the data would not be secure. We also have the value of personal information, which is something that is a new theory that's bubbling up in the courts right now, which is very interesting for a lot of the folks working in this space. There's also out-of-pocket losses. So like I said before, a consumer spent time and effort dealing with the data breach that they otherwise would not have spent before, as well as, if they purchased their own credit monitoring as a result of the breach. And then there's other damages theories as well that we'll get into. What's really interesting about the data breach and privacy space is that courts are more and more considering that personal information has value. And that's because we've been seeing this trend that companies themselves, when they have an initial public offering or when they talk about the valuation of their company, the companies will acknowledge that personal information has value because that's what they derive their value from as a company. You look at Facebook, they had a huge IPO, and a lot of that came from the fact that they had gathered so much information on consumers. So when I was litigating the Marriott case, I'm co-lead class counsel for the consumers in that case for a data breach that occurred because of the Starwood reservation system, which was later acquired by Marriott. When Marriott acquired Starwood Hotels, was breached, and it was a breach that occurred over 4 years. It was an intrusion that had not been detected. And so we argued in that case that consumers have a right to their personal information, and they have a right to bargain for the cost of that personal information, and that personal information has value. The court actually acknowledged in denying Marriott's motion to dismiss on this issue that personal information may very well have value. We'll of course have to prove it later on in the litigation, and we'll have to talk about how to come up with that valuation of consumer data. But this is a trend that a lot of courts are starting to recognize. In previous years, courts were reluctant to recognize that data, private information, had any value. But now there's a trend toward it, and companies need to be very careful about safeguarding data, because if it turns out courts determine that personal information has value, that could expose companies to a lot of damages after a data breach. There's a couple of other cases prior to Marriott where courts started acknowledging this as well, most of them coming out of California, and a lot of them having to do with very large data breaches that involved personal information such as social security numbers. So really the more sensitive the information, the more value that can be derived from that information. Another theory that I touched upon previously is this idea of the benefit of the bargain. So in Adobe Systems privacy litigation, you have consumers basically bargaining for software. And they would not have spent as much on Adobe products if they knew that Adobe wasn't providing reasonable data security. In Marriott, we alleged that plaintiffs would have paid less for their hotel rooms if they knew that Marriott's data security wasn't on the up and up. Now, again, these damages theories are subject to be proven. So these, the Marriott case, for example, that is a decision on a motion to dismiss. Later on in the litigation, we're going to have to use our expert to actually talk about what is the loss of the benefit of the bargain. How much less would consumers have paid for a hotel room had they known that their data wasn't being secure? And that requires a lot of expert witness time. It requires a lot of documents from the company to see if they placed any value on their security systems. So while the law is evolving and recognizing these new damages theories, I have to caution, the law is evolving, and we're determining how to figure out these damages each and every day. Moving on to post-breach investigations. This is one of my favorite topics as of late because it is very quickly evolving. So after a data breach occurs, companies have to figure out what happened. They have to figure out, what systems do they have to make more secure? What patches do they have to apply? What databases do they have to take offline because they're no longer supported? And they need to figure that out as a business function so that they can continue providing services to their clients and so that they won't experience another data breach on that issue again. But one trend we're seeing a lot is that defendants will try to shield investigations as to how the breach occurred via attorney-client privilege and work product. I don't blame them. This is actually very, very smart. But it's a tension that we have because consumers want to know, how did the data breach occur? Because when I'm litigating my case, I want to argue that defendants were negligent in not adopting reasonable security standards. And in order to figure out what those reasonable security standards would have been, I need to know how the data breach occurred. The defendants, on the other hand, say, but I need to know how the data breach occurred so I can tell my attorneys how to defend against these lawsuits. And so that is part of attorney work product. So as a result, what will usually happen is an entity who experiences a data breach will obtain counsel, and then that counsel will then sign a retainer agreement with an outside vendor. We've heard about, I'm sure everyone is familiar with the outside vendor FireEye and Mandiant. Some of you may know about CrowdStrike. Some of you may know that a vendor actually experienced their own data breach when a state actor actually breached them very recently. So these law firms will engage directly with the third party, and then that third party will investigate how the breach occurred at the direction of counsel. At least that is the theory. Plaintiffs, on the other hand, argue that that is a sham. The company would have had to engage a third party anyway as a part of their business practices. And just because the attorneys were on the contract doesn't make it necessarily work product. Whether or not it's privileged and the plaintiffs aren't allowed to see these investigations, it's a very fact-specific inquiry. And you have to do discovery, both sides do, before engaging in these questions, because the court is going to want to see, okay, how is this privileged, or what basis do you have to argue that this is attorney work product? Let me see the scope of work. Let me see the retainer agreements. So this is a very fact-specific inquiry. There's a couple of cases that have examined the post-breach investigation and whether or not it's privileged and it's work product. And more lately, we are seeing that if companies retain an entity with whom they had a previous business relationship, that the courts will typically find that any report about how the data breach occurred is not protected attorney work product. The analysis goes something along these lines. You already had a business relationship with this entity. They were already going to be performing these services for you anyway. And so you cannot shield it as work product merely because you've now hired attorneys. Because as a part of your business, as a part of your investigation so that you could continue providing services to consumers, you would have had to have done this analysis already. That's what we saw in the Dominion case back in 2019. That was out of Virginia. And basically, outside counsel tried to shield a report by Mandiant. And the court found that it appeared to be designated to shield material from disclosure rather than reflect the actual relationship between the defendant, outside counsel, and Mandiant. In Primera, that was the Blue Cross data breach case out of Oregon, Same thing. The court found that it was a necessary business function to figure out how the data breach occurred. Capital One, most recently, the court ordered the production of the Mandiant report. That case, there's still a lot of activity on the docket, and there's still a lot of back and forth because there are some other privileges that are coming out as a result of this being a financial institution case. So we'll probably see even more developing on that front in the Capital One case. Now, on the other hand, some courts have found that the post-breach investigative reports need not be produced. And I have a couple of cases on here that talk about basically that. The court in Arby's, Target, and Genesco, however, didn't really provide a lot of analysis or rationale behind that. In Marriott, however, again, a case I'm litigating, we found it a little odd. The court came to the conclusion that Marriott might later designate CrowdStrike as one of their experts in the litigation. So the court wasn't sure whether or not we would be entitled to their investigative notes and things of that nature. That's kind of an outlier case. We were surprised by that, but we may see in the future additional discussions about how experts play a role in litigation, especially if companies retain as expert witnesses in litigation the same entity that performs the post-breach investigation. A lot of attorneys who are on this call might be scratching their head at that because very rarely do you see a potential fact witness later be retained as an expert and have that information fully protected. We'll see how it plays out later on in the Marriott case, to be continued. But the takeaway to this is that facts matter. And companies who retain third-party servicers with whom they already have a relationship to perform the post-breach investigation, more likely than not, you're going to have to produce that report. Typically, if a company leaves it to outside counsel to find a new entity to perform a post-breach investigation, then the company has a better chance of those investigations being shielded by work product. So things to keep in mind if you're a company defending against a data breach, things to keep in mind if you're a consumer pursuing a company who has, violated your right to have your data secure. So things to think about. Moving on. So let's say we as a consumer have demonstrated standing. So we've shown the court that we have a right to be in court. We have a right to pursue our case. We demonstrate that we have some sort of tenable damages theory, that we're entitled to some money as a result of this breach. And we've obtained the post-breach investigation, so we know how the breach occurred. Now, this is typically when these cases start to settle. They either move on to another stage of the case called class certification. And that's when you basically demonstrate that by proving the case for the small set of named plaintiffs, that you can prove the case for everybody. They can either settle after you've gotten the class certified or shortly beforehand. And that's because the defendants realize that their exposure is getting pretty big at that point. So you can take the risk, you can roll the dice of going to a jury trial and facing additional scrutiny that could impact the company's bottom line, because no one wants to have the company's name continue to be in the press as a result of a data breach that happened years before. So companies will typically say, okay, let's have a discussion about settlement. And settlements should only be put together, and the facts of the settlement and the relief that you provide in the settlement really has to take into account the specific facts of the litigation. What information was compromised, right? Has the company already offered identity theft protection, and credit monitoring. And if the company already provided credit monitoring, was it enough? And if credit monitoring wasn't previously provided and credit monitoring is part of the settlement, then you got to know all the facts. Will credit monitoring actually help consumers? Does it actually address some of the information that was taken? Will it help consumers, prevent accounts from being opened? A lot of the times, if social security numbers were not stolen, if addresses were not stolen, if personal contact information was not stolen, sometimes you don't need a traditional credit monitoring service, because the chances of fake accounts being opened in a consumer's name when social security numbers haven't been taken in the data breach, you probably don't have to provide traditional credit monitoring. So there's not it doesn't sync up basically with the facts of your case. And that could be a problem. If you offer a settlement that doesn't actually address the data breach, then you're subjecting yourselves to something called objectors. There are people whose job basically is to object to class action settlements. There are not-for-profits that have been created for the sole purpose of objecting to class action settlements and, poking holes in the settlements and figuring out, why settlements don't address what actually happened in the data breach. These settlements should only be reached after arm's length negotiations. If there has been a large data breach that it received a lot of media attention, and there's a lot of scrutiny out there for what the company did. There's a lot of scrutiny in terms of how plaintiffs' counsel are litigating the case. Then you're going to want to tell the court that you hired a mediator who's well respected and knows the rules of the road, and that you settled the case knowing that you don't negotiate fees until you have agreed upon all the material terms of the deal. So never go into a settlement if you're a company saying, hey, I'll give you the attorneys like a couple $1,000,000. How can we make this go away? No, do not do that. You want to negotiate the relief you provide to the consumers first, because the last thing you want to do is create an argument that the attorney sold out the class, because at the end of the day, that's just going to hurt the company more, because you're going to be embroiled in litigation about objectors. Know the objector's common complaints. They will argue, if you're a plaintiff's counsel, that the case wasn't risky enough to be paid so much money in fees. They'll argue that sometimes you need separate representation for each and every potential separate state subclass. So if you bring causes of action as a plaintiff's attorney for consumers based upon different state laws. Some objectors, the new objection du jour, which has been failing in a bunch of courts across the country, but they make the objection anyway, is that because one state statute might have provided for X number of dollars, that they should have had separate counsel negotiating settlement for that class. Courts typically reject that, but the objection will be made anyway. So one thing you might want to consider is having additional counsel at the negotiation table to help work out some of these statutory damages issues. Objectors will sometimes argue that the notice plan was inadequate. Notice is really important in data breach cases. Courts now allow you to do notice via email, but you really need to work with a great notice provider to make sure that the email bypasses spam filters, that it uses words that will catch consumers' attention. These are things that an experienced notice provider will be able to help you with, and I highly recommend talking with someone who has quite a few of these under their belt, because that will help you develop a notice plan that will avoid objector scrutiny. Sometimes objectors will tie up litigation for years and years and years in the appeals process in the hopes of extracting green mail, Basically, you can pay objectors and their counsels a certain fee for them to drop their separate appeal that's above and beyond the money that most class members would get. The federal rules of civil procedure, thankfully, have been amended to address that issue somewhat, but it doesn't address all issues with objectors, unfortunately. There's some objectors who are just, they're ideologues and they're motivated by ego to have appellate case wins, and they will continue objecting in the hopes of getting a win. So just keep that in mind. Quick pay, that's basically when you agree to pay all or some of the attorney's fees to plaintiff's counsel. It can help with the extensive appeals process if you're a plaintiff's side attorney, but consider it carefully because it is a common issue that objectors like to complain about. So now that we've talked about litigating a case based upon the existing laws, we're going to briefly address how legislators are playing catch up. I talked previously about the current legal landscape of data breach laws and how there are data breach cases and how they're based upon outmoded causes of action. Most data breach cases are brought based upon a negligence cause of action. That is that the defendant had a duty to protect my data, that the defendant breached that duty because my data wasn't protected, there was a breach, that as a result of the breach, then I experienced damages. And the duty part of the negligence analysis is based upon Section 5 of the FTC Act, which says unfair methods of competition in or affecting commerce are hereby declared unlawful. Incredibly vague, but attorneys use that section of the FTC Act to say companies had a duty to safeguard data, and in not safeguarding data, that was an unfair method of competition affecting commerce. It has worked up until now and is continuing to work to talk about that. Negligence causes of action can also be brought based upon other theories, that defendant's duty came from other sources, like other state consumer protection laws, or by virtue of the relationship that the entity had with the consumer. So there's a lot of different ways that you can talk about negligence and duty as a part of that cause of action. But typically, most data breach cases look to Section 5 of the FTC Act. Again, there's some data breach cases bring them based upon consumer protection laws. The problem with a lot of consumer protection laws is that some of them require an existing relationship. So like a bargain for exchange or some kind of showing of reliance that the entity made some representations to consumers, and as a result, consumers thought their data was safe. The problem with this, though, is that if you have a large credit agency, for example, credit reporting agency that doesn't interact with consumers, it's more difficult to bring those causes of action. So tricky legal landscape for plaintiffs' attorneys right now with data breach cases and proving their cases. All 50 states, including the District of Columbia, Guam, and Puerto Rico, and the Virgin Islands, they've enacted legislation requiring entities to notify individuals if there's been a data breach. The problem with those is that most of them do not offer a private right of action that confers statutory damages. So, you can bring a lawsuit that says I should have been notified earlier. That's usually something you see in data breach litigation. Typically, that's not what's going to carry the day in terms of damages in these lawsuits. And security breach laws typically have provisions regarding who has to comply with the law. So we have like a patchwork framework of laws in the United States where data breach notification statutes from one state to another aren't consistent. So some states require that a data breach have a name combined with a social security number or something more, has been exfiltrated or provided to a hacker or an entity who didn't have permission to see it. And some states have requirements that are less than that. So it's a patchwork framework. It's very tricky to figure out how they all differ. There have been white papers written, usually by defense firms, that talk about the difference in the data breach notification laws. But again, as a consumer pursuing, privacy and security rights, typically these are not going to be the causes of action that carry the day at the end of the day. Also, private rights of action depend on those state-specific laws. Some laws do not allow consumers to bring lawsuits for violations of data breach notification laws. Sometimes those laws are only enforceable by a state attorney general. So it's really important before wading into these data breach cases that you have a fulsome understanding of who can actually bring these causes of action, because sometimes companies will send you a Rule 11 letter if you're not entitled to bring these causes of action, and you could be subject to sanctions. There's some federal statutes out there that consumers can rely upon to bring causes of action. Again, a lot of these do not allow for a private right of action, but consumers can look to these laws as the basis for the duty component of a negligence cause of action. So saying that a company had a duty pursuant to HIPAA to protect my information, and as a result of violating that duty, there was a data breach, that's a good negligence theory. So there's a bunch of different federal statutory regimes that we look to with these data breach lawsuits, and it really takes a lot of experience to wade through all of them and to know which ones are applicable to which cases. Individual states are starting to take note that the laws are insufficient to really protect our data. And the reason why they're insufficient is because if you're relying upon a negligence cause of action to protect consumers' information in a data breach, it's really only a matter of time until a defendant with the resources wants to take that issue to trial. And that could be a very tricky trial based upon the different components of negligence for each of the 50 states. It could be tricky. And if you base your theory of duty on a particular statute for one state as opposed to another, say, for example, one of these consumer protection statutes, it can make for a very tricky trial. So some states are thinking, we need to do more. We need to make it so that there's an automatic statutory penalty in the event of a data breach, so that consumers don't have to come up with a damages theory for, how to value personal information or benefit of the bargain. If we just make it a statutory penalty, then that's going to be enough of a stick to basically enforce the law to ensure that companies comply with data security standards, and also to make sure that those companies that don't comply are held accountable. Because when you have statutory penalties and it's much easier to prove your damages theory of your case, companies start taking notice. I'm sure that there's a lot of folks attending this webinar this morning that are very aware of the CCPA and now the CPRA. And that is because these laws can basically subject companies to a lot of exposure for data breaches specifically. Now, the California Consumer Privacy Act, that statute does not allow for a private right of action for violations of the privacy portion of the statute. And the CPRA, which was recently passed, that doesn't do a whole lot more for consumers. What it does do in terms of privacy and the ability to privately enforce that statute, what it does do is it allows consumers to privately enforce the statute for data breaches and data security incidents. And it allows consumers to bring those private rights of action to get statutory damages. So when you bring your lawsuit as a consumer, the company's exposure could be in the billions of dollars for a violation of the data breach component of that statute. We haven't seen a lot of these lawsuits yet, and that's because the CCPA, it's a very narrow scope of how you can bring these statutory penalty lawsuits. The definition of personal information as it's used in the CCPA is much more narrow than the other portions of the CCPA, specifically for data breaches. So the CPRA expands it a little bit, but we're still going to see that a lot of the cases that are brought pursuant to these statutes, they're very specific. They're the most egregious data breaches. They're going to involve social security numbers and names and birth dates. As a result of these statutes, we're seeing that companies are segmenting their data more. And they're basically making it so that sensitive information is kept in different locations. That's a really great idea. De-identifying data, that's a great idea. Higher levels of encryption, that's a great idea. Because if the data is encrypted, if it's exfiltrated, then the chances of huge statutory exposure in terms of these statutory private rights of action, it gets a lot less if companies protect their data. The Illinois Biometric Information Privacy Act, this statute has actually been on the books for a while. It was enacted in 2008, but it's gotten a lot more publicity lately because there's been these blockbuster lawsuits brought against companies. One of the earlier ones was this Facebook case. It was brought in 2015, and that's basically Facebook potential enactment of more of these statutes. If companies have enough disclosure about what they're doing with the collection of this data, how they're retaining it, and also having sort of opt-in policies regarding the use of that information for limited purposes, then companies can comply with BIPA. It's not a law that was designed to prevent compliance or to encourage lawsuits, but I think The reason why this law was passed is because it recognizes that biometric information is really the keys to the castle. As soon as a company retains biometric information, it is now the steward of information that cannot be changed. And if a company does not have the resources, the wherewithal, the sophistication, or the want to protect that data, and that data gets breached, then you now have the ability to basically impersonate anyone. You have the ability to get into unlimited numbers of accounts, and this is, again, it's information that can't be changed, and it's really important that companies recognize that. And I think that's sort of the reason why these laws have been passed. What's on the horizon? So Maine and Nevada, they both passed California-like statutes. They don't allow for a private right of action, but companies should still know about them because compliance is important. And there are some pretty strict compliance requirements in the statute. Many states are considering stronger statutory regimes, stronger statutory damages, again, so that we don't have to come up with a damage theory, benefit of the bargain, value of personal information, things like that. Some acts have been introduced in Congress, but as I'm sure you can imagine, the private right of action is really problematic for some lawmakers. But at the end of the day, it's a bipartisan issue. Everyone hates data breaches. Everyone likes privacy. So I think you will see some activity in state legislatures to ensure that that information is protected, to ensure stronger privacy rights and disclosure rights. But I don't think that anything is going to happen in Congress anytime soon because this private right of action is such a sticky subject to a lot of businesses who fear that it's going to result in an explosion of litigation. At the end of the day, though, I think that we can all agree that we hate when data breaches occur, and we hate when companies represent privacy and what they're going to do with our information inaccurately. So there does need to be something done. I think we can all agree on that. But it remains to be seen what will happen and how things will occur down the line with various legislatures throughout the country.
Great. Thank you so much, Amy. As you saw on the last slide, we do have Amy's contact information. If you have questions, we can do that, and we will pass them on. Again, you can see on the screen with this really, really important and very timely topic. So appreciate that. Now, for the last 33 years, my goal with this event has been to share information with attorneys and CPAs that's relevant, timely, cutting edge, and that you may not hear about elsewhere. Human trafficking is one of those topics, and this is a hugely important issue that's not being discussed as much as it should be, in my opinion, and frankly, many may not be aware of how prevalent this problem is. And it's something that can impact your clients, your friends, or even your family directly or indirectly. And the fact is, human trafficking is modern day slavery. So discussing this today and returning from yesterday is Greg Gutzler, and also really one of the most recognized experts in the country, especially as far as victims advocacy, is Lisa Haba, who's an expert in this area of the law. Now, as introduced yesterday, Greg is a named partner at DiCello, Levitt, and Gutzler, as a well-respected litigator,
Okay.
having
How are you?
both corporate clients and consumers in the largest cases in the country. Previously, Greg was a partner at one of the nation's most prestigious plaintiffs firms, and before that, a partner at an AmLaw 100 defense firm. Now, Lisa is an attorney in Central Florida. And one of the nice things about doing the event today virtually is we could really round up experts from all over the country. Amy's in Chicago, for example. Lisa spent her career working to eradicate human trafficking and sex crimes from society. She currently works for her own law firm, a boutique firm that focuses on civil lawsuits for human trafficking survivors against the individuals, businesses, and entities that would allow trafficking to continue, often in plain sight. She's one of the lead attorneys in the infamous Me Too case against the fashion mogul Peter Nygard. Previously, she served as assistant state attorney in Florida, where she prosecuted human trafficking, sex crimes, child abuse, homicides, and frankly, other violent felonies. Lisa serves as the co-chair to the Seminole County Human Trafficking Task Force. She's on the board of directors for Catholic Charities of Central Florida and formerly served on the board of directors for the Greater Orlando Human Trafficking Task Force. Throughout her career, Lisa's received several awards for legal advocacy. Most notably, she's honored with the award in 2017 as Prosecutor of the Year for the state of Florida from Pam Bondi, the Attorney General in that state, primarily for human trafficking, prosecution, and victim advocacy. Lisa received her Bachelor of Arts degree from Syracuse University and her JD from Ave Maria School of Law. So with that, it's my pleasure to introduce both Greg Getzler and Lisa Abba.
Good morning. Thank you so much for joining us. We are very excited to be here and share this very, very important topic with you. We are here to talk about human trafficking, which is modern day slavery. And we hear a lot about slavery historically, but slavery has not gone away. It is right here in our country, in the world as we know it. And the scariest part about modern day slavery is that no one is immune from it. Anyone can be a victim. So let's go ahead and take a look at the next slide. This is a map put forth by one of the foremost nonprofits in the country that deals with statistics and eradication of human trafficking, the Polaris Project. Polaris Project has taken notes on where the majority of human trafficking cases that have been reported have come in. And you can see from this map that the red areas are where you're getting the most human trafficking calls called into our hotline. And the places, of course, with the more blue colors are going to be much less cases. Ideally, we have a country we don't have any of these dots, but unfortunately, you can see that the hot spots, the extremely high numbers of human trafficking really are down both of our coasts. You can see Florida is a big focus of it, and you can see right where it crosses the Canadian border seems to be a very hot area. The Michigan, Ohio, upper Northeast has been a real big focus of human trafficking calls and human trafficking crimes across the country. Can you press the next slide? So one of the questions that often comes forth, and I hear it constantly, is why is human trafficking so prevalent? Why does human trafficking occur, and why are we seeing so much of it in the United States? Because most people, when I talk to them and they're not that aware of human trafficking, they think that human trafficking is happening overseas. It's those foreign people that are being brought here. It's those foreign people that are being enslaved. It's those people in other areas of the world that are dealing with this, but not here in the United States. And unfortunately, the reality is that's just not the case. There certainly are people in other countries being enslaved under human trafficking, but it's right here in our own backyard. And it's in the nice communities, in the poor communities, in every walk of life, human trafficking exists. So why is that? Why is human trafficking so prevalent? Well, we've got three major reasons. First is going to be that it's more profitable than drugs or arms. It is a multi-billion-dollar industry worldwide. right now. We have more money coming into the human trafficking realm than any other organized crime in the aggregate. So what makes that the case? Why is it more profitable than guns and drugs and the like? The reason is that there's continuous profits. A drug dealer can take a block of cocaine and they can chop it up into pieces. They can give it to their dealers. They can sell it on the streets. But when that product is sold, when that product is gone, what happens is that the cocaine is gone and they have to go back to their supplier and buy more cocaine. So there's constantly a revenue stream that has to come from supplier to distributor to dealer, et cetera, to promote the sale of that illegal substance. But when you're selling a human being, once you purchase that human being once, you can sell that human being over and over and over again and have an ongoing, continuous profit. One thing we see a lot with human traffickers, especially in sex trafficking, is that a human trafficker will take a person and they'll dope them up with cocaine, because what does cocaine do? It makes the person not sleep. And they'll put them in a hotel room or into a place where they can perform the sexual acts that are being forced upon them. And that victim might stay awake for 3 days working continually in the sex industry, doing commercial sex acts, not as a willing participant, of course, but as a slave to their pimp. Now, that continuous profit model is quite scary because the average life expectancy of a victim is 7 years. That means a woman or a child or a boy that gets into human trafficking, if you really think about it, if they enter that life at 13 years old, a majority of them are dead by 20. It's a horrifying statistic. And that continuous profit model is what traffickers do. They use up the human being, what they see as a commodity. They use up that commodity until it's either that person dies or no longer becomes useful to them. The last thing I'll tell you, the other reason that human trafficking is so prevalent is there's a lot fewer risks than selling an actual tangible product. When you have to go buy cocaine, for example, you have to keep going back and making a new deal. You risk running into law enforcement. You risk having a person turn on you. You risk every time that you have to buy or sell something, having a problem. But if you're selling the same human being over and over again, once they're completely a victim and obedient to the person that is trafficking them, there's far fewer risks because you've taken out one of the major supply chains. Can you go to the next slide, please? So I'm going to turn this over to my partner, Greg Gutzler, here to talk a little bit about the Trafficking Victims Protection Act, which is our federal statute governing these crimes.
Good. Thank you, Lisa. I appreciate it. I wanted to thank everybody for being here today and Randy for putting this on. And one of the reasons I wanted to do this was it's a great honor to be able to present this with Lisa, who is really one of the experts in the country and a true advocate for victims. And she puts her money where her mouth is. So I'm very honored to be a part of this. The other main reason I wanted to do this is to raise awareness. I did not truly understand the depth and the breadth and the terrors that are imposed upon so many people by human trafficking. I did not view the world in a way that I do now, having learned about it. And as Lisa told me, you'll never view the world the same. You'll never walk into a bar and look around and not be thinking about whether that person is there willingly, whether that person perhaps is a victim. In hotels, the same thing. So I'm very happy to be here. So for the first slide, it's breaking down the statute. Again, as I talked about yesterday with the Anti-Terrorism Act, this is not meant to be an in-depth legal analysis. It is meant to provide you more of a conceptual framework so you can think about how these things work. You can think about how the law is attempting to have a common sense approach to addressing a problem. And in most cases, I find that statutes generally comport with common sense and do a decent job. And there are going to be some ambiguities in the statute that make it difficult to enforce. And that's occurred with the statute, by the way. There's a lot of dissent among people as to, is the statute broad enough? Has it been written correctly? And so let's talk about it. First of all, the word trafficking is a very interesting word that is very, very commonly misunderstood. The most important thing that I want to say is that with respect to the Trafficking Victims Protection Act, which protects against sex trafficking, it does not necessarily involve transporting a person across the state line. Most people think that's what it means. It does not necessarily mean that. that may be encompassed within the statute, but to sexually traffic somebody, it is much broader. It is much broader than just importing them or exporting a person across state lines. That is not really the essential component of sex trafficking. So let's go to the statute. And there are a variety of statutes here to talk about it. And Lisa's going to talk about the forced labor and the labor trafficking. And I'm going to talk more about the 18 USC 1591 sex trafficking. So Lisa, do you want to talk about the forced labor and the labor trafficking, if you would, please? And then I'll do the sex trafficking, and we can show how they come together, how they have kind of a common underpinning and a common theme of protecting people in slightly different ways, in slightly different contexts. So Lisa is an expert on all of these issues, and she has kindly allowed me to do the sex trafficking piece, and she's going to talk about the labor trafficking piece. So back to Lisa, please.
Thank you so much, Greg. And, I think Greg doesn't do himself justice. He truly is an expert in the subject matter as well. But let's talk about labor trafficking for a few minutes here. So we've created a slide that kind of breaks down the statute into a visual, because sometimes I find that it makes it a little more easy to understand a statute when you can see it almost in a visual form. Like all statutes that require a mens rea, person committing this act has to be doing it knowingly. A person cannot inadvertently commit labor trafficking. They have to do it knowingly. Now, the person has to provide or obtain labor or services of a person through one of four different means. And before I continue on that, I want to make an important note of distinction. Greg will get more into this in the sex trafficking portion. But a person who is under the age of 18 is treated differently than a person who is over the age of 18. When a person's under the age of 18, obviously we have parents, we have guardians, we have legal custodians that are in charge of that person to make their lawful decisions for them. So if a person chooses to enter into employment, a parent signs off on that, a guardian signs off on that, a person responsible for the well-being of that child makes the decisions on their behalf. So understand that the requirements for a child are slightly less than a person who is an adult. But I'm going to focus a little bit on the adult portion of it right now, because that's going to be probably more relevant to what we're going to see with labor trafficking. We'll see a lot of child labor in other countries. I'm not saying we don't see it here in the United States, but it is less than what we see with the adults. Now, labor trafficking is when a person is put into service, when they have to provide labor or services through one of four means. Either they're forced or physically restrained or threatened to provide that labor trafficking, which is going to be our first box. The second one is going to be if they're offered serious harm or threat. So if a person is being threatened, if they're being hurt physically or non-physically. And we'll get into that in just a moment here. If there's abuse of law or threats, and we'll get into that in a moment as well. Or if there's a scheme, plan, or pattern that is intended to cause fear. So let's look at that and understand it a little bit better for a moment. If a person's being forced to do something, if they're being physically restrained, if they're chained to a bed, for example, they obviously are being physically restrained. If they're locked in a room or in a house, they can't leave. They're being physically restrained. They're being threatened. If you don't do this, I'm going to hurt you. That would obviously qualify as force or threats of force. But if we talk about serious harm, what does serious harm actually mean? Well, the statute has broken it down and said that there can be physical harm or non-physical harm. And that's a really important distinction, because physical harm is what we think about. Threats, beatings, sexual violence. Maybe it's rape, maybe it's something else in that realm. But people do a lot of things to avoid being hurt. But non-physical harm can be a serious harm too. If you're threatening something that would cause psychological harm, truly instilling absolute terror or fear into your victim. If a person is being financially harmed, I've seen people literally threaten to have their entire lives bankrupted, destroy their families financially. That can be a form of coercion too that can constitute serious harm. Or reputational harm. You might be thinking reputational harm, how serious can that be? But take it outside the realm of a 30, 40-year-old adult and put it into the hands of a 13-year-old child. There is nothing more important to a 13-year-old than their reputation. I have seen 13-year-olds do insane things to protect their reputation. And I've seen teenagers attempt suicide over reputational issues. So don't underestimate the risk of reputational harm. A trafficker is very, very good at one thing: finding a vulnerability and exploiting that vulnerability. They will seek out what the vulnerability is. And if it's reputation, they'll use that the same way they would beatings on somebody else who would be manipulated a different way. If we go to the next slide, we'll talk about abuse of law. This is one that we see sometimes quite frequently with labor trafficking, where threats of deportation are used. I have a client that I used to represent that was brought to the country under a lawful means. She entered the country lawfully. She ended up working for somebody and wasn't actually allowed to legally work in this country. And the person that was using her labor initially hired her under the pretense of paying her, and then basically turned around and said, yeah, well, you're not actually allowed to work. So now that you are, you're going to keep working for me for free, or I'm going to call the authorities and have you deported. And the country she would have been deported back to was a very dangerous country. And suffice to say that a person in this country who is a victim of trafficking potentially has a better lifestyle than a person being returned to the country that she had come from. So I have to obviously be vague, protect the client's identity and information, but the deportation threat in the United States is a very real threat, is used frequently to manipulate and control victims. The threat of arrest will have you arrested. We're going to accuse you of things that you did or didn't do. The threat of detaining them or institutionalizing them in some capacity are often uses of the legal process used for illicit means. And lastly, if we go to the next slide, before Greg moves on to sex trafficking, using a scheme or plan to do any of the things we just talked about certainly qualifies as well. And Greg, I'm going to turn it back over to you to talk about sex trafficking. Thank you.
Very good. Thank you. Okay. So like yesterday's presentation on the Anti-Terrorism Act, you will see in the Sex Trafficking Act, which is actually called the Trafficking Victims Protection Act, you will see a convergence of criminal and civil law. And very similar to yesterday, the Trafficking Victims Protection Act, we call it the TVPA, or the statute, the federal statute that deals with sex trafficking. You will see that one of the predicates for the civil claim that Lisa and I, for example, would be bringing, which we've done in the Nygaard case, is you show that the criminal statute was violated. And that's 18 U.S.C. 1591. And so what happens is that the civil relief provision, which is 18 U.S.C. 1595, says very simply that whoever is a victim can sue the perpetrator for damages, essentially. And the perpetrator will be defined here in the criminal statute, which is 18 U.S.C. 1591. And you will see it's similar in a lot of ways to both the Anti-Terrorism Act as well as the labor trafficking. And it begins with knowingly. And for any criminal statute, labor trafficking, anti-terrorism, sex trafficking, you're going to have what the criminal law requires as a certain state of mind. And lawyers like to make up fancy words, often Latin, and it's called the mens rea. That is, did you have the sufficient bad mental state of mind, intent, knowledge, such that the criminal laws should in fact impose upon you a sentence. So the Sex Trafficking Act requires first a certain state of knowledge, a knowledge of the perpetrator. And that knowledge is of a variety of different things that are a part of sex trafficking, a sex trafficking venture. Those include things like recruiting, enticing, harboring, transporting, which is kind of the common sense trafficking, but that's just one small part of the Sex Trafficking Act, providing, obtaining, or maintaining. So you have a variety of different actions that must be done knowingly, and that is really meant to capture the overall scheme of sex trafficking, because the way it really often works, and Nygaard is a great example. Nygaard surrounded himself with employees and sex workers that he would use and enlist to lure and entice new girls to him. And so he would have these young, attractive women go out and find other women for him. And they were able to successfully lure and entice a lot of people in because they seemed harmless. They were just younger, pretty girls. And they said, hey, I know this really great model. He's got his modeling company guy. He's got a fashion company. he's got an island, he's got boats, he's got all of these things. He can get you into modeling and fashion and maybe even acting. And so every person's going to want that dream. Every person's going to want to do that. And so they were brought in. Those people were knowingly enticing and recruiting. And so if we look at that, you really understand how these things really work. And to really do a sex trafficking venture like a Peter Nygard or a Jeffrey Epstein, you will always see a network of people around them that are willing, they are complicit, and they're actually quite savvy. And I hate to use that word because it's usually used in a good way, but it really should be in a negative context. These people are deceitful and manipulative, and they entice and lure and recruit people in. And Lisa's going to talk a bit about victimology, because the first thing that I asked is, why would anybody ever do that? Especially a lot of the time, the people who are doing the recruiting are actually former victims of that same person. Nygaard's a great example of that. So why would they do that? And I'm going to leave that to Lisa. It's a very complex sociological and psychological phenomenon, but it's very, very real. And in our case, we've seen that over and over and over. So let's go back to the statute. Someone who knowingly engages in recruiting or enticing, harboring, transporting, all of those things. Okay. And so that is meant to deal with the people who are directly involved in, let's say, the physical contact component, bringing the person in, putting the person in a certain location, actually assaulting the person, things of that nature. And if you see on box number 2 on row 2, there's also the or someone who benefits financially. So the first box in row 2 is dealing with the people who are involved in the actual physical logistics. The next one is anybody who's profiteering from it. So again, the statute is trying to get to the common sense root of things and to try to stop it. Stop the people who are luring, recruiting, enticing, harboring, transporting, and also the people who may be somewhere in a back room or somewhere on the internet, if you will, who are in fact profiting from this enterprise. It's meant to cut off the entire flow. It's meant to cut off the venture. And then the next component of the statute requires that the perpetrator, which could be the profiteer, or it could be the person involved in the luring, enticing, or the actual assault, knowingly or in reckless disregard that a commercial sex act will occur either by force, fraud, or coercion, or that a commercial sex act will be engaged in with somebody under 18 years old. As Lisa was mentioning, you do not need to prove force, fraud, or coercion with somebody under the age of 18, because it is statutorily presumed that anybody under that age is, of course, not a willing participant. Therefore, de facto, it has been coerced. It is not voluntary. It is assault. So that is how it goes. So on the one hand, force, fraud, or coercion against somebody 18 or older, or anybody under 18. You don't need to show force, fraud, or coercion. That also makes sense, because people under the age of 18 are presumed not to be able to voluntarily, willingly, knowingly consent to any type of sex act. Okay? So I'm going to go to the next slide, and I'm going to explain a couple of these concepts real quick. Under the age of 18, you're going to hear a lot of talk. You'll see things on TV where, well, you know, I didn't see the identification, or how could I have known? I didn't truly know the person was under 18. The person didn't tell me. And sort of like other statutes, you're not allowed to stick your head in the sand. You're not allowed to put on blinders. There is some degree of due diligence, some degree of culpability. You must act with some degree of reasonable diligence and be cautious. And of course, this is incredibly important when you're talking about younger people and you're talking about sexual assault. So when we're talking on this issue, the law does in fact recognize that either the perpetrator has actual knowledge, let's say they saw some form of actual proof the person was under 18, or they acted in reckless disregard of the fact that the person was under 18. For example, the person was getting picked up in a high school bus, Now, that's going to lead you to believe that a lot of people that are riding a high school bus are under 18. In fact, the vast majority will be. That's an example of acting in reckless disregard. The law has also put in, the statute has also put in a component about having a reasonable opportunity to observe the minor. Now, there's some disagreement in the case law as to whether a perpetrator needs to, or the prosecution needs to show that the perpetrator acted in reckless disregard and had a reasonable opportunity. The other way to think about it is whether it's they acted in reckless disregard or they had a reasonable opportunity. And I know that these seem like trifling distinctions, but they're really not when you're talking about convicting somebody. And if it's an and, if you have to show both, it's obviously much more difficult. So the and the or become very important issues in criminal and civil liability. I just wanted to highlight that issue as the interesting ways in which the law tries to catch up with the real world. And sometimes it creates ambiguity and the courts try to fill in the void and figure out what was meant. And you're going to have all kinds of interpretations. The next issue is force, fraud, or coercion. And I wanted to talk about this. This is a really interesting topic to me because when you deal with a lot of victims, we prefer to call them survivors, but when you deal with survivors, what I have found shocking, quite frankly, is how many survivors don't know what rape is. And I don't mean that, I mean that in the most respectful way to them. I don't mean to belittle them at all. And the reason is they're hard on themselves. That's also victimology. And what you find is that a lot of the survivors deal with guilt and shame. And they always say, I should have done something differently. I shouldn't have been there. And sometimes they will say, well, I wasn't held down. I wasn't shackled. And that's what always astounds me and makes me feel sad because they say, well, I wasn't tied up. And many people, including survivors who knew they really didn't have a choice, will still cast guilt upon themselves and blame upon themselves because, quote, they weren't physically restrained. And that's not what the law says. That's not the real world. That's not how it works. And I'm glad the statute recognizes that. The statute does talk about force, fraud, or coercion. Now, force does, in fact, have the element of physical constraint. Okay? That is what most people, or many people, connote with sexual assault or rape, physical force. That's not the reality. That is just a small subset of how sexual assault occurs. And we can think about many examples, and let's talk about that. Another way is, and I want Lisa to actually talk about this. This is a really sobering slide. It's a difficult slide to see. And Lisa's going to talk about this based on her firsthand experience as dealing with a lot of survivors and her experience as a prosecutor, and explain what this branding or marking really does, what it's meant to do, and how it works, especially with younger men and women. So I'd love for Lisa to talk about this because this is a really powerful and difficult slide to work through.
Thank you so much, Greg. I was very taken aback the very first time I encountered branding on a person. And the best way I've been able to explain branding is this. When a farmer owns a field of cattle, and there's a farmer next door that also owns a field of cattle, and they don't want to mix up which cattle belongs to which farmer, the farmers will often brand their cattle to determine the property and the ownership of that cattle. The cattle is seen as a chattel, as an item, a piece of property. And as a result, each cow will be branded so that the owners would know who that cow belongs to if it were to get out of one of their fences or one of their pens. Well, similarly, traffickers, especially in sex trafficking, have taken to branding their victims. And some of them, like the one on the top, the DLA with the king, was a big case that went about. It was not a case I was involved in, but it did get some publicity on the internet. And that particular individual put the crown with the DLA initials on every victim. Other victims, and I've shown you a couple examples here, we blurred out the name, but one of them literally put property of with a rose, which was his insignia. A lot of victims have to refer to their pimps by certain names. We've seen many victims refer to their pimp as daddy. And that way, if they get arrested, they refer to him as, that's my daddy, that's my boyfriend. But understand that victims are treated like property, like we talked about. So when they look at something and they're branded, it's an insignia, not only in their own mind, but in the mind of any other person that sees them. This person belongs to X. And if another pimp were to come in and try to recruit that person, the brand is supposed to let them know this human being is already possessed. They're already owned by another person. So, once again, it's a way to not only degrade the human being, to show ownership, and to truly be the epitome of what I think would qualify as force. Forcing a brand onto somebody is certainly not something that any victim would willingly put on themselves. And Greg, back to you.
So I think that's it's a graphic slide to demonstrate that what the statute tries to get at with the force, fraud, or coercion, or anybody under 18 is what I would say generally under the umbrella of unfair control. And that's really what force, fraud, and coercion and the interpretations of those terms have really been designed to do. Is the victim in a situation where the perpetrator has unfair or unreasonable control? And the branding and the marking is an example of really what I think is very clearly unfair and unreasonable control. Because no, I don't think anybody really wants to be branded. That doesn't make sense. It connotes a sense of subjugation and control that is not even up to human dignity. So that's where it is. So we talked about force. That is more the physical force. The branding or the marking, I would say, is an element of force and coercion, which we'll talk about next. But let's talk about fraud. Fraud is another component of the statute. And fraud is very easily characterized in the entertainment world. It's the casting couch. Come on to my office. If you want to roll in this movie, here's what you got to do. That's the most obvious example. It happens all the time in entertainment, in the modeling industry, and it certainly happens in the fashion industry, as we know from the Nygaard case. His signature maneuver to lure and entice was to use young models to go out and find other pretty young women and offer them jobs as a model, as somebody who would get a great job in the fashion industry. It happened over and over for more than 50 years, if you can believe that. It happened to hundreds of innocent people. And so fraud is a really easy way to play on people's dreams, to prey on their highest aspirations, and to lure, entice them in. And then once they get there, there's going to be a bad situation. They are going to be stuck. They are going to have nowhere to go. And I'm going to go to the next slide, because this to me is the most powerful component of the TVPA. This is coercion, and Lisa talked about this in the labor trafficking context. Coercion is very, very broad, as it should be. Again, coercion does not mean, under this statute, necessarily physical constraint or physical harm. It can. It can certainly mean the threat of serious harm or physical restraint. So it's broader than actual force. It's the threat of serious harm or physical restraint. And as we know, serious harm is very, very broadly defined, again, as it should be. And it encompasses psychological harm, financial harm, reputational harm. And what you will see is that sex traffickers are incredibly good at manipulating and finding people with weaknesses, finding people who have been hurt, finding people with insecurities, finding people who are naive, finding people who have huge dreams that will do almost anything for it. And then they lure them in and then threaten them psychologically, financially, reputationally, physically. Nygaard's a good example. He would do all of those things. In fact, what would happen is he would lure young girls to his private compound in the Bahamas. There was a gate to his 150,000 square foot home, which had several acres on the beach. And there was a massive, it was about a 15 to 20 foot gate. And you couldn't get out. Once you were in, you couldn't get out. He would have people take their passports. There would be photo shoots of them, front, head, behind, take down all of their stats. So it's a very intimidating situation. Their passport's been taken, they don't have any money, and all their personal information has been gathered. They weren't allowed out. And they were all supplied with alcohol and drugs, as well as physical restraint. So Nygaard understood how to use psychological, financial, reputational. He used all of that. And he created a sex trafficking venture spawning every country that we can think of, certainly every continent. We know he's been to all of them. And hundreds of victims. We currently represent 85 people. And we actually represent his two sons. So believe it or not, his biological sons have sued him because Peter Nygaard had a sex worker have sex with them when they were underage. And he ordered the sex worker to do that. So we represent people that have been through unbelievable things, and we can speak firsthand to how the coercion worked. Nobody felt like they had a choice, and it wasn't always being shackled. I want to really be clear about that. It's about psychological harm. It's manipulation. It's a variety of things that you can develop over periods of days, weeks, months, and years to make people do things that in a normal setting they would never do. That's coercion. And the sex trafficking statute, the TVPA, recognizes that. And as Lisa talked about, abuse of law. Threat of deportation was another thing that Nygaard would use when he had illegal workers in the Bahamas who didn't want to leave. That was the only job they had. He would make sure that if you want this job, if you want to stay in the Bahamas and not get deported, you've got to do what I say. And these were young people who were victims themselves. They had no choice. And so that's coercion. And so this kind of sums it up. And again, we don't need to read the slide. I would just say the statute really tries to capture the fact that sex abuse can occur through any type of unreasonable control over a victim. And that could be force, fraud, or coercion, or somebody under 18. And the second to last component is for the federal government to act. It has to affect interstate commerce. That's just a simple function of our federalist government. And here it's actually a very interesting component that interstate commerce, most people think of as, again, always crossing state lines, meaning perhaps the victim was transported across state lines. That is not how the statute works. The statute is far broader for protecting people. And here it says, for this, the perpetrator or the victim neither has to cross state lines. They do not have to. In commerce, affecting interstate commerce is very, very broad. It could mean using the instrumentalities of interstate commerce. Easiest example is using a telephone, using a wire transfer that crosses a state line. So cell phones, wire transfers, hotels, anything of that nature, advertising, all of those things will affect interstate commerce. So you will see that it's very, very broad. So even if a perpetrator and a victim remain in a certain state, let's say it's the state of Georgia, as long as any instrumentalities of interstate commerce were used, let's say the internet, then that person can be guilty of the federal crime, not just a state crime, because there are obviously state laws as well. And the last component is a commercial sex act, okay? And that has two components. The sex act is very broadly defined, and I don't really need to go into it, but it's very broadly defined what constitutes a sex act. It does not necessarily mean intercourse, by the way. It does not. It does not even mean a consummated sexual act, because the statute is broad enough to encompass. For example, a John shows up because of an internet ad to have sex with a 13-year-old child. Once that person shows up, they can be convicted. There's a case called United States versus Wilson, and that perpetrator never touched the victim. They were lured in, it was a sting, but that person is guilty. So you don't have to consummate the sex act. In addition, if there is a sex act is very broadly defined. Okay? And as it says here, there's no requirement the defendant had sex with the victim. And if it's not a sex act, let's say it's massage or exotic dancing or something of that nature, the statute, the overall human trafficking statute, perhaps not the sex trafficking statute, may be invoked. That's the labor statute that Lisa was speaking about. And let me just go back real quick. The commercial component is also very broad. The commercial component means anything of value given to any person. So you can think about all the ways in which value could be exchanged, and it isn't necessarily money. It could be a tangible or an intangible piece of value. A promise to do something for somebody is absolutely value. A promise to not do something, e.g., for example, deport somebody. So this is a broad statute that is meant to stop people and makes it a criminal violation for anyone to knowingly lure, entice, recruit, transport, obtain, actually do the assault, conceal, and in a situation in which a commercial sex act will be involved with somebody under 18 or involving force, fraud, or coercion, and anything where any of the components of the sex trafficking venture affected interstate commerce. Very, very broad statute. It's meant to stop these networks, and it's meant to stop people that do it one time. What I mean by that is this statute does not require that it be a repetitive act. It doesn't require that. It requires one act in which all of these elements are met. And so it's a broad statute. I think that it could use some more tightening. I think it needs some ambiguities removed. But I think you're going to view the world differently when you see how prevalent it is, and that map that Lisa showed was really powerful to show how much of it is going on, probably right under your nose. I know that Cleveland is right up by the border. I'm in New York. It's happening there. Lisa's in Florida. Amy Keller, the previous presenter, she was in Chicago. It's happening everywhere. And it's really important that we all be aware, we be vigilant. The other thing I'd like to say is speak up. We have so many people that say, I don't want to get involved. It's not my business. I think it is our business. I think it's everybody's business. And if I can get on my soapbox, I really hope that everybody can become more aware, more compassionate, and speak up if something's happening. And the next component of the presentation is Lisa. And she's going to talk about, again, another area of her expertise where she's really great at it. I've seen her do it. And that's dealing with the survivors, dealing with victims, being an advocate, dealing with some of the very complex psychology for these people. And we do a lot of that with the Nygaard survivors. There's a lot of therapy, a lot of understanding we have to have. And Lisa's an expert in this, and I'm looking forward to her talking about it.
Thank you so much, Greg. So let's go to the next slide and talk a little bit about if you're a lawyer and you're dealing with somebody who's potentially a sex trafficking victim, where do the traffickers find their victims? Who can be a victim? And how does the lawyer deal with that? Well, we have a little diagram here. There's, of course, like I said, no size fits all. Literally anybody can be a victim of sex trafficking. And I've had clients who were straight A students in high school with loving families, both their parents, no poverty in the picture, and I've had quite the opposite as well. Sex trafficking does not have a type of person it targets. It's anybody with a vulnerability, which literally can be any person. So sex traffickers find their victims. We talked about vulnerabilities. Here are the 6 common ones we see. And the most recruited age group for sex trafficking victims is females between the ages of 12 and 14. So what are some of the reasons that victims fall prey to traffickers? Well, substance abuse is a major one. Almost every drug dealer is capable of being a sex trafficker as well. You have a victim who's potentially strung out on a very heavy substance, heroin, crack cocaine, something of that nature. They certainly are going to have trouble holding a job. And as they continue to grow and they continue to age, obviously that is something that can be exploited and used to control them and manipulate their every move. Poverty is a huge one that's preyed upon. If a person is impoverished, they want better things for themselves. They want to be able to change their life. Then poverty is something that gets used frequently to prey on people and offer them that quote unquote better life, when in reality it's a lure into the horrible world of trafficking. A history of sexual and physical abuse we'll talk about in a moment here, but that pretty much puts an individual into a unique category where they're more likely to be preyed upon a second or a third time. A number of our sexual abuse victims that I've dealt with over the years also were victimized as children. And There's, I'm sure, a very cognizant psychology from a therapist that could explain why that is. I don't necessarily know the psychology behind why they're more vulnerable to being re-victimized, but I can tell you the statistics do show that that is very much a reality. Looking at the purple box as well as the box at the bottom in the green, runaway or homeless youth, as well as children in child welfare or foster care. There's a commonality there. If a child has run away, there's a problem at home. If a child is homeless, they don't have somebody to hold them every night and say, I love you, you're special, you matter. A child not hearing that leaves a hole in their heart, and that hole needs to be filled. And they're constantly seeking to be loved. We all want to be loved as human beings. And that very innate human nature of wanting to be loved is very easy to manipulate. And what are sex traffickers good at? Manipulation. So they'll come in, I love you. I'm going to be that person to make you feel safe, to give you a roof over your head, to give you the security and the care that you so deserve. In reality, once again, it's a lure. The last one is the disconnection from your educational system. A lot of traffickers, a lot of trafficking victims are found through our educational systems. Our teachers are trained well in understanding what to look for. And when a child is sleeping in class every day because they're working at night for their trafficker, or they're just not showing up to class frequently, those are the types of things that a teacher will flag and say, something's not right here. We need to look into this. And that those questions being asked can be very, very instructive to changing that child's life and getting them out of a human trafficking situation. Go to the next slide. Just very, very quickly, some underage statistics that I found rather horrifying, but I generally mean that, horrifying but true. I want to make sure that you understand really what we're dealing with. The average age of a person who enters pornography, and I'm not talking professional pornography, I'm talking all pornography, is 13 years old. We talked about before, the average life expectancy for a victim is 7 years. And even though 1 in 7 runaways are likely sex trafficking victims, when you're a runaway, you are so vulnerable to a trafficker. The most horrifying statistic in my mind is that when a child runs away within the first 24 hours, 1 out of 3 will be recruited for sex trafficking and solicited by a trafficker. Now, if we talk about victim psychology, the most vulnerable children, we just talked about this, are going to be your homeless and runaways, individuals that need help. And that's very important because if you click it again, please, the number of children that are in the homeless, runaway, what we characterize as throwaway youth, children that don't have that stability at home, 60% statistics have shown of those children in foster care have PTSD entering their teenage years from sexual abuse as a child. 10% have it from physical abuse. So the reason that's significant is because when a child has been subjected to those types of abuses and they're suffering from PTSD, those children are experiencing PTSD before they ever meet their trafficker. What a vulnerability to exploit. What a horrible situation to have a child entering adolescence with PTSD and nobody's looking at it, nobody's treating it, but the trafficker can spot it from a mile away. They can smell the blood in the water and they'll pounce. And then go to the next slide. So let's go through the brainwashing of a pimp. And I get asked all the time, how does this happen? How do people get brought into this life? So I'm going to give you a quick example. This is a very classic scenario that happens frequently. You have a person who is a runaway child or a person who's got an abusive parent at home. They're starved for attention and they meet a pimp. They don't know it's a pimp, of course. They think it's somebody great. But he begins showering her with love and attention. He's buying her things. Here's a phone. I'm going to get your nails done. I'm going to get your hair done. This girl starts to feel beautiful. He says all the right things. I love you. I want to marry you one day. We're going to be together forever. And this young girl thinks, wow, I finally found it. I finally found somebody who cares about me, who loves me. Well, she's desperate to hang on to that relationship. She's desperate to not lose it again and be alone once again. And so the pimp preys upon that. The trafficker will create a dependency. I find it attractive when you walk like this, when you talk like this, when you have sex like this, I want you to do X because I find that more attractive and it makes me want you more. And she'll do it. And slowly he's training her to obey his every command. He begins erasing her identity by giving her a nickname. You're not Samantha anymore. You're Charity. Or you're not, so-and-so anymore. Now this is your new name. And that he creates a new identity with the new person that he's building. He forces her to watch educational videos, pornography. Because what does pornography do? It educates you as a child in the ways of sex, so to speak, right? But in reality, what it is the absolute degradation of the female for the benefit of the male in the video. And I'm using a very female-male oriented conversation right now. Obviously, that is the majority of what we see. But please do not believe that men cannot be victims, boys cannot be victims too. They absolutely can be. But just for this example, I'm going to stick to the female role. That pornographic video is going to teach her degradation and the pleasing of a man as the primary purpose of sex. Then the pimp begins to pull back. Well, I love you so much. I wish we could get married. I wish we could be together forever, but we don't have any money. So I need you to do one thing for me. And one thing turns into two things, and it turns into a lifestyle. And of course, there will be a day when she says, I don't want to do this anymore. I don't want to be, having sex with strangers. I just want to have sex with you. And that's when the beatings will usually begin and the violence begins, because the pimp is willing to do whatever it takes to make sure his property obeys and acquiesces to his every command. They also will very often remove the family structure and support so that they feel isolated. There's nobody around them to help them. And so, if we can click it again, please. The result is you end up with a person who's desperately in love with and desperately afraid of their pimp. And go ahead and very quickly, we see this constantly on the internet. Victims are lured. They are brought in to, into conversations through a variety of lures. We've kind of talked about it in our example, so I won't belabor it. But obviously, all the different lures that can happen on the internet can happen to anybody. If you have a child who's in the realm of 11 to 14, they are probably being solicited in some capacity or another using these various lures, trying to find their vulnerability. Go to the next slide, please. What we end up seeing for those that fall prey to it, you'll see ads posted on various websites all over the internet selling people. They present as willing victims, but I can tell you the majority are not. The majority of what appears online to be a willing victim is a woman who is doing this because she's a trafficking victim. So we have several complexities in litigation. There are several bullets here, but recruiting other victims, that can obviously be a problem. A person claiming to not be a victim. A person, because they haven't identified. Many victims have been manipulated into believing that they are absolutely did this by their own choice, when in reality they fell prey to a lure. Recruiting other victims I skipped that top one, but I wanted to come back to it and say that many victims have been forced to bring in other women. I've seen cases where a victim's been told, your children, we know where they live. We know where they go to school. They have pictures of them entering the bus. The victim knows that their child's very life is at stake. And so when they're told, you better go find me a new girl today, and she better be 15 or 14 years old, when you're really weighing, I can go find somebody else or I can have my own child be harmed, that's an impossible situation to put a person into. But those are the recruitment things that we don't always see on the surface, but are happening behind the scenes to manipulate people. We talked about the love bond that can be created. We've talked about the drug or alcohol addiction, which can drive people to do insane things. A lot of times we run into the problem that traffickers are smart. They have victims rent the hotel rooms that they use in their own name, because that way, if it ever got pulled, oh, well, she did this on her own. She's an independent person acting as an independent person. I had nothing to do with it. She rented her own hotel room. She posted her own ads online. And a lot of our victims are mischaracterized as prostitutes, when in reality, they are not. They are victims of human trafficking. We can easily explain this. There's a lot of different things that can be used Frequently, it's trauma from childhood and the trauma of their own victimization with this trafficker. But these are not complexities you should shy away from. Obviously, Greg and I are always willing to do a consult if that would be helpful to you. For trauma-informed advocacy, trauma, and I'll finish up here in about a few seconds, trauma is going to affect how people how they view the world. It affects how their brains function. It affects how their minds work. And it can cause a lot of issues. Number one, your victim is not going to trust you right away. A victim will never trust the lawyer when they first meet them. Most victims tell me 4 stories before we get to the truth. And that's common. That's not unusual. That doesn't mean they're not trustworthy. It means they're testing you or they're afraid. They have trouble communicating. There's a psychological phenomenon called disassociation, where they almost look at it from a third-party perspective. They disassociate from the event they had to endure. It's a way your brain keeps you safe from the harm you've endured in your life. They have trouble controlling their emotions. I've had trauma victims scream at me and then apologize the next day. I've had them go absolutely ballistic on me and then tell me they didn't mean it. That's common, and it's part of the trauma as it affects them. They have trouble expressing themselves. They lived it, and every time they talk about it, they relive it. Not remember it, but relive it in their own minds. And you'll notice that trauma victims have trouble understanding cause and effect. They have trouble understanding that you need to go do X to get to Y. It seems so common sense. You'll feel like you've explained it 15 times so you're blue in the face. But a trauma victim really struggles with cause and effect. What they know how to do is live in the now and in the moment, because they've been in survival mode for so long. And the most important tip I can give you is, if you have a victim of trafficking, a victim of trauma in any capacity, involve a trauma therapist, not just any therapist, but a trauma therapist early on. It'll make a world of difference to working with your victim and your survivor. So the most important tips I can give you very quickly are: be transparent with your victims. If you promise something, follow through. I don't care how difficult that might be. Don't make a false promise, because if you lie to them, they will never trust you again. Be predictable. I give my victims, I'm going to do 1, 2, 3, and then we're going to talk again. And I oftentimes will put it in writing so they can't, forget or have a misunderstanding. Insert client control. We talk about that in every case, but it is so important with these cases. They need to know that you're in control, but from a perspective of, I'm going to help you, not I know what's best for you way. You don't want to be like their pimp. You want to be different. You need to be reliable. If you say you're going to be there at 10 o'clock, you need to be there at 10 o'clock. If you're going to call them on Tuesday, you need to call them on Tuesday. You need to be proactive in your support. Anticipate problems. Talk to their therapist. Be in a position where you know what's coming, and anticipate that by letting them know so they aren't surprised. Because when you surprise them, it's going to trigger a PTSD episode. Be patient with them. And I can promise you, this is so easy to say and so hard to do, but be patient. They are difficult clients, but it's worth it in the end to help them. Very, very important to find your boundaries in your role. Don't accept calls at 10 o'clock. This is a person who has been starved for attention and love. They will suck up as much of it as they can get. And if that means it's from you, they'll take everything they can get. So I draw very clear boundaries. I'm not going to talk to you after 6 o'clock tonight, but I'd be happy to call you at 9 o'clock tomorrow morning. When they know the boundaries, they'll abide by them. But if you don't set the boundaries, they will take and take and take until you are drained. And lastly, you need to understand what their triggers are. Their therapist can help you with this. You need to know what their triggers are, what's going to set them off, what's going to cause a PTSD episode. And you need to prepare for that and make sure that you are not only preparing for it, but anticipating it and preventing it from the future. All right. And this is the very last thing. There are 3 things you can do. You can report to law enforcement if there's a criminal case. Involve your local law enforcement. Involve your human trafficking response team. We can, obviously, Greg and I are very involved in filing civil lawsuits against traffickers and businesses that support traffickers, hotel chains, taxi cab services, the like. And in the enumerated states that I put on the screen, there is an expungement option where a victim of human trafficking can erase their criminal record, anything that happened because of their trafficking situation. Obviously, that wasn't their fault. They didn't intend it. So we've talked about civil lawsuits. If you want to talk more about them, obviously, please feel free to reach out to Greg or I anytime. We'd be happy to consult. And with that being said, please take down this number. Keep it in your phone. You know, as Greg said earlier, if you see something, say something, report it. It might save a life. And thank you so much for your time and attention today. We really, really appreciate it.
Thank you so much, Lisa and Greg. You know, clearly a very, very important topic and something that people absolutely need to know about. One of the things that we've been asked year after year is get some perspective from the bench. Judge Mark Bartolotta is kind enough to return. He has spoken before, and your feedback was we wanted to hear from him again. So in 1992, Judge Bartolotta was hired actually in Lake County, where he worked as a trial attorney in the civil, juvenile, and criminal divisions for almost 20 years. In 2013, he went to Geauga County to run the criminal division as chief assistant prosecutor. While there, he was on the team that successfully prosecuted the Chardon High School shooter, for those of you from Ohio. When the governor of Ohio, John Kasich, needed to fill an open seat in Lake County, Mark Bartolotta returned to the probate court as a judge, and since taking the bench, he's handled all aspects of the court, ranging from guardianships to will contests, adoptions, and administration. Mark earned his undergraduate degree from the University of Akron with a major in finance. He actually had some of the same licenses that I did, with a Series 7 broker's license and insurance licenses before turning to the law. He furthered his education at Cleveland Marshall and graduated in 1989. So with that, we're very privileged to have Judge Mark Bartolotta join us this morning with his view from the probate bench.
All right. Good morning, Randy. Thanks. Thanks for the intro. Not to make me any older than I actually am, but I started law school in '89 and finished in '92, and then got hired out here in Lake County in '92. So I've been in public service in Lake County for over 28 years now. It seems like barely over 28 days, so I've been blessed. So as Randy said, I've been here at the probate court since 2013. First got appointed, and then the following year I ran to win my own term, and then just last month I was up for re-election and won that term as well. So now I'm starting my second full term, so starting my 8th year here on the bench. I still feel like a kid and a rookie, though, as far as the probate world goes, so I'm still learning, and I'm hoping that you'll learn a little bit from today as well. I'm going to try and break up the dry and boring part of the presentation with a little bit of a salacious case that happened about 93 years ago this week in Perry. It was a homicide case. We'll talk about that in a minute. So I'll intersperse that with some of the drier details that I'll be going over. Unfortunately, we do have to cover that as well. I'm not exactly sure who my audience is today. I didn't get a roster. My bad. I didn't check to see who was all going to be participating. So I'm not sure if this is strictly a Northeast Ohio audience, or if it's nationwide, or what the case may be. But in any event, a lot of this will have to do with primarily with probate here in Lake County and the state of Ohio. Some of the things I want to go over with you folks first regarding the goings on here at the probate court with all the COVID shutdowns and restrictions and things of that nature. I just wanted to let folks know what's going on here at the court. Recently, probably about 2 weeks ago, when Lake County's COVID numbers started shooting through the roof, we went back to our previous COVID schedule, where the front of the court, the counters were closed to the public except for emergencies or for scheduled appointments. So that's been reinstituted for the time being. So if anybody has any business with the court, filings, things of that nature, it'll be done primarily through the mail. If you have something you need to get here in a hurry and you're not too happy with the performance of the U.S. mail at this time, We do have a drop box installed in the front lobby, so you could drop off filings there if you want them to be processed or looked at that same day. We do check that box and empty it several times a day, so if you have a filing that needs to get in that day, you could always do that, drop it off. And you could still always use the mail, obviously, and those will be processed as they always had been. Now, if there's some emergency situation that comes up, we have been accepting documents emailed and or faxed to us with the hard copy original put in the mail or dropped off at a later date. But if there's some emergency that arises that the court needs to look at right away, you could always call us first, let us know that it's coming, have actual conversation with someone so we know to look for it, and email it to us or even fax it to us. They won't be considered the actual filing, but at least we'll be on notice and we can get started on whatever needs to be done in the emergency situation. So don't hesitate to do that. And if we deem that it's not an emergency, we'll let you know. But if it is, we'll certainly get started. And when the original does come in the mail or through the Dropbox or whatever, we'll process that. And I'm not too concerned with filing deadlines. Those, the Supreme Court put out some guidelines as far as timing on things, so we follow those closely as well. So besides that, the things that we still do here in the court with the COVID contested hearings, we still have been doing those a little bit here in the courtroom, but we are trying to do most things by Zoom or by teleconference. So typically, while we'd come in, you might have a in-chambers meeting with me and talk about the case. We're going to do more of that by Zoom. We've been doing it like that since March anyhow, but we're going to step it up a little again since the Lake County numbers have been going up. Although in the paper yesterday, they said that we're out of the purple now. I think we're back into the red. So that's at least encouraging news to a certain extent. So as far as those emergency things go, let us know about that. One of the things that came up during the mid portion of the COVID this year regarding electronic filing, we have instituted e-filing for our marriage licenses. As you know, or some of you may know, to apply for a marriage license, you used to have to come in person, fill out the application at the counter. The application would then get downloaded by one of the clerks and put into the computer, and then you'd get sworn in, take the oath that you're not, relatives or you're not under the influence of anything, and we could get your marriage license at that point. And that was a process that might take, maybe a half hour. So now with this e-filing, we have it set up through our website that applicants can fill out the application ahead of time. As a matter of fact, they're required to now fill out the application ahead of time, and it'll get sent to us electronically. And then you've got the opportunity online to schedule your appointment to actually come in to have your marriage license prepared and take your oath and take it out with you. So in the past, you might come in and have to wait, through 6, 8, however many couples back there waiting to get processed. Now it's more of a regimented system where you'll have a specific time to come in. You'll be the only one scheduled for that time. The process will be within a matter of a couple of minutes, and you'll be able to get out here with your license in hand. So far, that's been working very well. Our clerks have mastered the process pretty easily, and so far it seems like the folks that are using it have mastered it pretty easily as well. So, if you are thinking of getting married yourselves or have clients that are, make sure you tell them to go to the website and take care of that online, and we'll get you out of here in a jiffy. All right. A couple other things going on at the court. As I said, the Zoom hearings will be continued for a while, and the teleconferencing will. Trials have kind of been put on an unofficial hold. We didn't really have that many trials scheduled during this past COVID period anyhow. One was actually scheduled for next week. That's been continued into next year, sometime indefinitely, so we're not exactly sure when that'll come. The one good thing about probate court, we don't have the speedy trial requirements as criminal courts do. So while a lot of things are obviously of an important nature typically the things that go to trial aren't anything time related or time sensitive that we can't postpone for a little bit. And hopefully with the vaccines that are all being produced and coming out recently, that we'll nip this thing in the bud and get back to a more normal schedule. I was kidding with my court administrator yesterday, saying, "Oh, the only way I'm going to get out of this seminar today is if I come down with COVID overnight." So that didn't happen. She yelled at me for tempting fate. As I was preparing a little bit last night, I got a call from the prosecutor's office saying that one of the detectives that I did a search warrant with early in the week just tested positive. So I'm like, oh, great, I did jinx myself. So, but so far so good. So no problems there. One of the other new things here at the probate court in Lake County, it's not new as of today, but it's been new over the past year that we're quite proud of, is our volunteer guardian program. That is up and running and functioning quite well. And for those of you who don't get involved with the guardianship work, basically one of the main duties of the probate court, if someone needs a guardian, if someone's not able to handle their own health care or safety or their financial affairs, they may need help doing that. And if they don't have family members, or if they don't have any powers of attorney in place, then they were stuck, what to do. And so over time, we've been developing this program over the past 5-6 years, actually. And about a little over a year ago, we actually went live with it and got it into place. And we have a program through Lifeline, which is a nonprofit organization here in Lake County. It's a service provider here in Lake County. So Lifeline administers a program for us. We just generically call it the Volunteer Guardian Program. And basically what it is, it's a number of people in the community who are volunteering to be guardians for people, for strangers actually. So they'll all go through a screening process, a background check. They'll go through the mandatory education that the Supreme Court mandates, which involves some classwork, fingerprinting, the whole bit. And then we get them trained. We get them hooked up with an existing guardian to maybe get a little legwork under them and to realize what their duties and obligations are, to get their feet wet. And then eventually we let them strike out on their own as a volunteer guardian. And so what that deals with, with the guardianships, there's guardian of the person and guardian of the estate. So they're only dealing with guardian of the person, dealing with their placement, where these folks are going to be living, whether it's in a facility, whether it's in their home with assistance, or whether it's somewhere else. And then also taking care of their healthcare needs, making sure that they're getting treatment that they should, making sure that their medications are provided for them, making sure that they're being med compliant so that they're taking their medications. And so these people fill a huge role in Lake County here, because in the past we didn't have this program, and it was basically up to the court to try and scrounge around and find people to volunteer. As a lot of you attorneys know that do work here in the probate court, we would call on many occasions asking for attorneys to step in and act as guardians for these people. A lot of times it was guardian of the estate as well as guardian of the person, but and that we understood that was a burden to a certain extent, especially those of you who were very gracious and took a lot of cases on for us over and over again, accepting our calls and agreeing to do it. So it's been very helpful for the attorneys to do that. Now with the program in place, the volunteer guardians are handling strictly the guardianships of the person. And so if an individual still needs help with their finances and a guardian of the estate is necessary, then we're still looking to the bar. We're still looking for attorneys to fill that role. But at least in those occasions, there's more than just the volunteer money that's available to help pay fees for that. The fees are still reduced, so you're still doing good work and God's work for us by continuing to volunteer to do those type of cases too. But we're trying not to burden attorneys with the guardianship of the person. So in any event, the program's up and running. We got a lot of volunteers. We got some full-time staff members who are helping to train those folks. And every week, there's not a week that goes by where I'm not appointing 3, 4, 5 people, volunteer guardians through this program. And so every chance I get to get out and speak in front of a group, I'm always soliciting as well, soliciting in the legal way. For anybody who has any groups or church groups or social groups that are looking for something to do to give back to the community, this is a big way that you could help give back to the community. So, if you have any questions or like to volunteer or know anybody that does, look to our website or to Lifeline's website, and the opportunities are plenty. Trust me, especially this time of year, everybody feels their duties to give back, and a way of giving back all year round would be through going through and volunteering with the Volunteer Guardian Program. So that's my plug for the program. It's been running great. We do appreciate everyone's efforts in making it happen. Lifeline's our big partner, Lake Health, Deepwood DD, Adams Board. So we're getting a lot of support from those agencies and from other smaller agencies as well. So let's keep that going. And I appreciate all the work that all the attorneys have been doing on that. A little bit about some different changes that have been going on. This is part of the dry part of the presentation where I'm going to go over some things that the practitioners may or may not be aware of already. There's some new Supreme Court forms that came out recently this past month that are being used, substituted for some old forms, primarily on estate cases. The inventory and appraisal form is new. There's some changes on it regarding like the automobile exception or the automobile transfers. Those are listed on there now. So make sure you're using the form that's been amended as of October 1st of 2020. So the primary difference there with the value of the automobiles, there was a time when you're limited to a number, I think 1 or 2 vehicles could be transferred to a surviving spouse automatically, and those assets wouldn't be considered part of the estate, but they had to be listed on the inventory so we'd know what the set-off would be to the spousal allowance. So that's been raised to $65,000, but unlimited number of vehicles. So, if you have like 3, 4, 5 vehicles, that's aggregate value is $65,000 or less, theoretically, any or all of those vehicles can be transferred directly to the surviving spouse by just taking the death certificate and the form up to the title bureau, and you get those transferred right away. Now, one of the new things that's coming out, that may come out, we'll talk about more of this in a little bit. There's House Bill 464 that just passed the House a couple weeks ago, and it's currently in the Senate. I thought it would get voted on this week, but it got stalled due to COVID in the Senate Judiciary Committee, so I'm not sure if it'll get voted on by the end of the year. Hopefully it will. But one of the items in there has to do with the automobiles. So in the past, if the spouse elected to take one or more of the vehicles through this method, then the vehicle number 1 would be charged against the spousal allowance, the $40,000 spousal allowance. So in other words, if she took 3 cars that total less than $65,000, the lowest valued car would be offset the $40,000 spousal allowance. Now the anticipated change that may go into effect if this bill gets signed by the end of the year would be to make that first car not necessarily charged towards a spousal allowance, but any second or third or subsequent car, the lowest value of that car would be. So it seems like what the legislature is trying to do is basically give them 1 free car so that they don't have to offset their spousal support allowance based on the value of that car. So that's one of the things. And we'll talk about a little bit more about the House bill a little bit later. So that's the first form I want to notify you of. And just for those of you who are practicing in probate court, it's Form 6.0, Supreme Court 6.0, and it's called Inventory and Appraisal. So that'll be on there. And then the whole packet that goes along with it will be on there as well. There's another new form that's coming out. It's Form 8.3. It's a summary of the general rights of the surviving spouse, talking about the spouse's election to take against a will. So there's some new information on there. So take a look at those and use those. The form for application of family allowance, we kind of talked about that a little bit with the cars. There's a new form for that, Form 7.1. So that one's a little bit different. Take a look at that. Now there's a new form that's not an updated form, but it's a brand new. It's a motion by guardian for real estate sale by consent, and it's Form 28.0. So in the past, as far as doing a land sale, as a guardian, you had to open up a whole a new case, a civil case, to do a land sale. Now, if there's some consent that's provided, the guardians could motion the court to approve the sale with the consent of those necessary. So look at Form 28.0 for that. Along the lines of that, we have 28.1. It also goes along with that one, and so those are basically the new forms to look at, and we have them all downloaded online on our website. And so take a look at those. The old ones would have been removed already. So if you have a stockpile of inventory of your forms, please go through them and make sure you're still using the most current set of forms. And not only will you find them on our website, but the Supreme Court has them on theirs. Ours are just tailored to Lake County, so it'll say the court on top and my name and all that. But for folks that aren't in Lake County, just go to the Supreme Court's website with their forms, and those new forms will be on there as well. Okay. Let's see. One of the new things, relatively new, I guess, is your ability as an executor or administrator of an estate, or potential executor or administrator. If you're folks who are doing med mal cases or personal injury cases, you don't know if you have a case yet, and you want to get your hands on medical records of a decedent, before you had to open a full estate and get somebody appointed as executor or administrator. And now, as of this past year, the process has been changed a little bit to allow an application to release the medical records filed without opening a full estate. So you'll still have to get somebody, either an executor or whoever could potentially serve as administrator, can file to get this release done. And on our website, our court administrator, Christine Gibaldi, has done a nice job of putting together checklists and packets of the various different estate processes and other processes for other types of cases too. But checklists will be on our website. It tells you what paperwork to use, what documents to go through, and how to proceed to get these things accomplished. So in particular, the new checklist is called the Application to Release Medical Records and Medical Billing Records. It's substantially cheaper than opening a full estate. I think our charge is about $80 to do this, as opposed to several hundred to open the estate. And what it does is it gives me the ability to make an order for all healthcare providers to make the records and billing information available to the executor or the administrator, who would be executor or administrator, without having to go the full route. That way, you as a practitioner, as med mal, for a med mal case or a PI case or whatever the case may be, you've got the ability to get your hands on these records and look through them first to determine if you do have a case. And if you don't have a case, that's fine. Then you're out maybe $80 for looking at the records and whatever the cost of the records may be. But it helps you in streamlining whether or not, number one, you'll take on a case, and number two, whether or not there's a case there to be investigated and looked into. And so what happens is we give you this authority to get the records, and you'll track them down however you need to, and you'll get a hold of them. And then over a certain period of time, I'm not sure off the top of my head how long, but we give you several months to look through them, and then just let us know whether or not you're going to go further and open the full estate and pursue a civil case, pursue a wrongful death or a PI case, and that way you'll know before having to do it. But you need to let us know here whether we're going to keep this case open. So if you go through, you get the process started, you go through the application to release these medical records, you get them, you look through it, and you decide, look, we don't have a case. You discuss it with your client, with the potential executor or potential administrator, and you find out, look, it doesn't look like we've got a good case here. Let us know so that we could close it out, all right? And by the same token, if you're looking at it and you're seeing dollar signs and things are jumping up, like, hey, they've got a good claim here, we're going to pursue this. Let us know that as well, and then you'll have to go through and open the estate in the typical fashion, and that way we could appoint the individual either executor or administrator, and you could get the ball rolling on that. So that's relatively new, and actually I just noticed the other day in the News Herald that Bob DiCello, I don't know if you're out there, in his column, his law column there, he actually wrote a little article about it. So so that was very helpful. So thanks, Bob, for that. Got to give him a shout out. So he did a nice little summary of it. So if you look in the News Herald, it was probably this past week in his column that he puts in there every once in a while. Look at that. But definitely look at our website, look at the checklist, and we could kind of walk you through it. And as every checklist admonishes or advises or disclaims, this is not legal advice. This is only guide for you as practitioners. So use it as a guide and do your own legal analysis and legwork and figure out what you need to do. But we're trying to be as helpful as we can, especially we get a lot of pro se people in here too. So that was the purpose of making the checklist. But the attorneys are benefiting from them also. So don't hesitate, to look at those and use those, and they'll help you maybe save you a little bit of legwork and maybe some phone calls up here. So take a look through those, and hopefully that'll help streamline things for you and help you decide whether you've got a good case or not, or whether you want to pursue anything further, any wrongful death or med mal or anything of that nature. All right. Let's see what else. Went through the updated forms. All right, so now we'll do a little bit of the entertainment value of the case. And I celebrated a birthday the other day, and my staff got this for me. So I don't know how to get it on camera. So I've got my little old bobblehead to help me, entertain myself throughout the day by nodding yes or making decisions no. Although we did get a lot of feedback on the bobblehead. Some people thought it looked like Judge Gibson. Some people thought it looked like Judge Cannon from the 11th District. So if you ever stop in, take a look at it, you could give us your feedback as well. But he's always watching. So, all right. All right, so those of you who are members of the Lake County Bar Association may have seen a article that I wrote for the Lake Legal Views last month. And for those of you who read it, I'm sorry, this will be a little bit of a rehash. For those of you who haven't read it, it's kind of an interesting case that harkens back to my days as a prosecutor. As Randy told you in my intro, I spent about 21 years as a prosecutor, 20 of them here in Lake County and a little bit of time in Geauga County. And so these things sometimes intrigue me, but I somehow caught wind of this case, and it was a homicide case from way out in Perry, little old Perry, Ohio. But it happened back in December of 1927, so about 93 years ago this week. And it wasn't a typical homicide. I mean, back then, homicides weren't that typical anyhow. But even by today's standard, this was not a typical homicide. This was a case that was a young female named Velma Van Wert. That was her maiden name. Ended up getting married to a young man, and several months later, killing him with a hammer out in little old Perry, Ohio. And so it was scandalous at the time. It made the news pretty much nationwide. It was pretty well known throughout, at least through the Midwest, and certainly here in Ohio. But what had happened was young Velma, she was about 21 years old, from Cleveland, a big city girl. Cleveland at the time was big city, right? And she liked hanging out at nightclubs, going out drinking with her friends and singing till dawn. She was a piano player as well, and liked to go out and dance. So this was back in the 20s. And at some point in time, she found herself engaged to some 50-some-year-old restaurant owner from Cleveland, and apparently saw, a nice life ahead of her with this guy who had some successful restaurants downtown. But then shortly before her marriage was supposed to take place, she ended up meeting this 26-year-old farmer from Perry. His name was Ed West, and he was the son of a man named West as well, dad's first name. I don't know what his name was, but TB was his initials, TB West. So he owned a bunch of nurseries. And apparently these nurseries were well known throughout not only Northeast Ohio, but throughout the country. I mean, he had orders placed from all over the country, and he was very successful and made a lot of money in this nursery business. So, nursery businesses have been big on the east end of the county for quite a while, apparently. And so, he was one that definitely reaped the benefits at the time. So anyhow, young Ed, I believe he was about 26 at the time, he met Velma, and they hit it off, and she decided she's dumping the restaurant guy, the 50-some-year-old, and wants to get married to this 26-year-old. He was a nice guy, a hardworking farmer, worked on his dad's nurseries quite a bit. That was his job. He helped run the nurseries, and I'm sure it was probably a 6 or 7 day a week job for him, all day, every day, taking care of not only nursery workers, but the produce, the crops, the plants, the shrubs, the trees, all that. So he was hands-on, and that's what he did. And so I guess you could say he was a stereotypical, simple, farmer, did his job, got his hands dirty, worked up a good sweat every day, and then wanted to go home and relax. So he met this young Velma. I forget how they met, but anyhow, they got married. And it was big news in Perry because this socialite from Cleveland was going to come into Perry and move into Perry with her young husband and start a life out there. So it was all the news in Perry, big news out there. Bigger than the power plant is now, I suppose, right? I don't know. But in any event, so they got married. He built a house, a nice bungalow for them out there in Perry, near the farms, near the nurseries, and they lived there together. Now, everybody wanted to see her and meet her. Ed's dad put on a big wedding and invited a lot of the Perry community, and almost everybody that got invited showed up because they all wanted to meet this young Velma, this socialite from Cleveland, making a big splash out here in Perry in Lake County. And so they did, and she was the hit of the wedding, the belle of the ball, so to speak, and quite popular early on. Well, that popularity ended rather quickly as they found out more about her, and the Perry lifestyle didn't quite fit the Cleveland lifestyle that she was accustomed to. Going out, staying out, it was scandalous that she would stay out past 10 o'clock on nights. Big scandal that she smoked cigarettes in public, and apparently she's a pretty heavy smoker too, I from what I understand. And so, she and her husband tried to socialize with his friends and go to dinners or whatever, and they just found that they weren't meshing. Her lifestyle just wasn't meshing with the bucolic lifestyle, I guess, of Perry and Lake County. And so less and less of his friends started hanging out with them. And so they started turning to her friends for their social activities, starting to go into Cleveland more, driving, whatever 30, 40 miles it is to get into Cleveland from Perry, and spending, several nights a week there going back and forth, the nightclubs, the jazz clubs, the dance halls, bars, things of that nature. She loved it. Ed, not so much. Ed was still a homebody. Ed still liked being, hanging around at home after a hard day's work, having a nice dinner, sitting around the fireplace, maybe having a beer or a drink or something and reading the newspaper. So, their two divergent lifestyles weren't meshing either, they've come to realize. So that discrepancy in their ideas of what they wanted to do for social activities started to take a toll on their marriage, each growing resentful of the other for obvious reasons. And, Ed started going less and less downtown with her to go see her friends. She would still go down there and hang out with her friends and do the typical thing she would do, which nowadays isn't all that scandalous as far as what she was doing. She was going dancing or going singing or playing the piano, whatever. But, to the Perry, quiet Perry Lake County lifestyle, it was something. And so it was around Christmas time of 2027, right? So in December of 27, they had planned to go to a friend of hers in East Cleveland, which was a nice community at the time, I suppose. But her friend was throwing a big party, a Christmas type party, card party, and they were invited. Ed reluctantly agreed to go. So as it was getting closer and closer to party time that week, she was more excited. Ed, not so excited. And so ultimately on the night of the party, which was December the 6th, so about 27 or 70 and 93 years ago this week, it was party night. Ed comes home from work. He's exhausted from working the nurseries and all that, and she still wants to go to this party. She's adamant about it, and he's like, "Well, why don't we just stay home? You can play the piano. We'll sing. We'll sit around the fire. We'll have a nice dinner. I'll read the newspaper." Apparently, he had a big chair that he liked that he'd relax in after a hard day's work. She was adamant, "No, I want to go downtown. I want to go. I want to go." Well, then Ed starts railing against this friend of hers who was throwing the party. Her name was Mabel Young. So, Mabel, Velma kept in touch with Mabel and continued to do things with her. And she really wanted to go to Mabel's for this party. So Ed started bad-mouthing Mabel, saying you shouldn't hang out with a person like that. She doesn't fit in with our lifestyle. Apparently, there were some allegations back then that Mabel may have been a lesbian and had like that kind of a affection towards Velma. It wasn't quite clear, but that was kind of the insinuation. But in any event, Velma wanted to go. Ed didn't want to go. So they started arguing. And the argument started to get a little physical. And so they started exchanging, insults and talking back and forth, and they got heated and getting in each other's face and whatnot. Well, earlier in the day, Velma, while Ed was at work, Velma was working on some drapery or something up in their bedroom, hanging drapes or something. So there were some tools up there in the bedroom. And they got into like a pushing match or shoving match. And Velma grabs a hammer, claw hammer or ball peen. I'm not sure what kind of hammer it was, but she grabs a hammer and tells him, settle down, don't take a step closer. Well, he takes a step closer, and then she just hauls off and hits him right in the head, knocks him down, continues to hit him numerous times while he's down on the ground. He was a bigger guy, and she was a tiny thing. From what I understand, she may have been, 100 pounds soaking wet. But she took him down with that hammer, and he was down on the ground. He tried to get up several times, and she, made sure he wasn't getting up and knocked him down, kept him down, and apparently knocked him out at some point in time. Well, while he was unconscious, she bound him up, his ankles and his feet and his hands, and kind of left him there. And he was, bleeding and unconscious. And she decided, well, I'm going to go. So she continues to gets dressed up, and hops in their little sports car and drives down to East Cleveland to Velma's house, goes to the party, has a good time, and spends the night in East Cleveland. So, doesn't mention anything to her friends there at the party, carried on as if nothing happened. And then she actually stayed at her mother's house overnight in East Cleveland. And so the next day she wakes up, as if nothing was wrong. She and her mom go downtown and go Christmas shopping. So the two of them are Christmas shopping all day. The next day on the 7th, I think that would have been, right? Yeah, December 7th. Seeing all the sights of downtown Cleveland, all the displays and all that good stuff. Even buying him Christmas gifts. And so they were out all day long. Meanwhile, while they're shopping, Ed's brother is wondering, how come Ed didn't show up for work? What's going on? Ed's brother goes to the house. I believe his name was Tom. Goes to the house, and he finds Ed dead on the ground, bound up, bloodied. It was a pretty bloody crime scene. Hammer was left there. No sign of Velma. And so, the authorities didn't know what had happened. Who did it? Was it a break-in? They found that there was no forced entry anywhere, no forced windows, no broken door locks, nothing like that. And so it was a whodunit to them at that point in time. So they spend that day going around looking for Velma to see what, if anything, she knew about this. And so eventually, after Velma and her mom are done shopping, the sheriff, his name was Rasmussen at the time, Edwin Rasmussen, a couple of his deputies track her down at her mother's house the next day or early evening after the day of shopping. And she wasn't really looked at as a suspect at that time. They just knew that there was no forced entry in the house and knew that she was gone with the car. So they wondered, did you leave like a door open or something? And she's like, why? What do you mean? Well, your husband's dead at the house. And, she didn't know what to say at first. And then I don't know if it was a pang of guilt or whatever, but she admitted that she did it. And so the sheriff's deputies were kind of surprised that, she admitted to this homicide. And so they, of course, arrest her and bring her over to Lake County Jail, and she's held at the jail. So they end up questioning her that day or the next day, and she gives a full confession, talking about how the two of them were arguing about going to this party and how she wanted to go, he didn't want to go. She alleged that he pushed her and that she was defending herself, although she didn't really come out with like a full self-defense type argument or statement for some reason. But in any event, she gives a full statement and a blow-by-blow, actually giving details about when she first hit him, that he went down, how he tried to keep getting up, and he would have been fine if she had not continued. But she decided, to finish the job and repeatedly struck him over and over again. Told him about how she bound him up around the ankles and the wrists and left him there to die. And so, she gave a full confession and all of that. So it was, sometimes you fall into a confession like that when the police were starting to investigate. So it wasn't a real quick investigation. Everything seemed to add up as to her story and to what the physical evidence showed. She, I don't think she had any injuries on herself, though, which I guess played into it. But in any event, she got charged with first-degree murder, and back then it was a capital offense. And back then, the manner of execution was electric chair. I don't know if it was Old Sparky back then, like Ohio's old electric chair used to be called Old Sparky. I don't know if it was back then or not, but that was the penalty for the first-degree felony or first-degree murder back then was death by electrocution. And so she, spent the next several months at the Lake County Jail. She had a couple of attorneys representing her. The lead attorney, I forget his name. Hang on a second. A man named Francis Polson, and that's Polson with the P, not Colson with the C, like our current prosecutor. But he wasn't around back then. So Francis Polson was her attorney, and the Lake County prosecutor at the time was a man named Seth Paulin, Paulin. So the two of them were set to go to trial. Trial date was set for March the 6th in 1928. So about 3 months after the homicide took place. And so I think we'll leave you there for a little bit and go back to the nuts and bolts of the presentation, and we'll finish up just to tell you what happened at the trial after we go over a few other things here, a few other things going on with the probate world. So as I talked about earlier, the legislature has this omnibus probate bill in front of them. It's been worked on for the past year, started in the House, and over the course of, since January through November, there have been several amendments and changes and additions and deletions. And so finally got to a version where the House voted on it, and the vote took place, it was introduced into the House on January 9th of 20. It passed the House on November 19th, so just about not even a month ago. From the House, it got introduced in the Senate on November 24th. It got referred to the Senate Judiciary Committee on December 2nd. And so day before yesterday, on the 9th, it was scheduled for a vote in committee. But from what I understand, they didn't have the vote because of, I don't know if they had enough people there because of the COVID or not, but the vote was postponed. So my understanding is they hope to vote on it next week sometime. But it passed the House unanimously, so it was a unanimous passage through the House. So I don't think it's going to have any problem in the Senate, but as we all know, you never know what happens till it's done. Like I always used to say as a trial attorney, you never know what a jury's going to do till they announce the verdict. Same thing here. So, but for all intents and purposes, the bill has been kind of buffed and shined and ready to go. And if the Senate passes it, there are some changes that'll occur at the probate court. The first thing I talked about was having to do with the selection of automobiles by the surviving spouse. It changes the language from if you have one or more automobiles, then that first automobile is offsets your spousal allowance, the $40,000 spousal support allowance. Now it says if you do more than one car. So it appears that that first car that the spouse elects to take won't be charged against her spousal allowance. And then if she takes more of the cars, she's only charged with the value of the lowest vehicle that she decides to take that way against her spousal allowance. And the rest of the cars, while they'll be transferred to her and not part of the probate estate, they're not going to be charged against her allowance. So that's the big change there. There's some changes in the guardianship law regarding what some of the expanded powers of what guardians can and can't do. The biggest one has to do with disclaiming awards present interest or contingent or expected interest in the ward's property. It does allow for some of that by the guardian, and that's all going to be subject to court approval. So that's something to watch out for. One of the big things that I'm interested in, and that kind of dovetails with our volunteer guardian program, is that the legislature is hopefully going to pass this that allows a nonprofit organization to serve as guardian of the person for indigent, or for people, not necessarily indigent, but for people who don't have people that could serve as guardians for them. And so as I talked to you before about our volunteer guardian program, the state of the law now is that if I appoint someone from the volunteer guardian program, that person, that volunteer, their name is the named guardian. So if John Doe becomes a guardian of Mary Smith, his name is on the appointment papers as official guardian John Doe, right? So what this statute will allow us to do is have the volunteer guardian program named as the guardian, as opposed to the individual volunteer. And the thing that makes that important to us here in Lake County is that, you know, we have volunteers that'll come and go, and while you may be the guardian initially, for whatever reason, that person may step down or may not be able to serve anymore, and may have to be removed for any other reason. And if that's the case, while we still have the ward being basically cared for by the volunteer guardian program, that named volunteer is no longer a named volunteer. And so in order to get a new volunteer named, we have to start the process all over. We have to go out and give notice to any family members that are out there, and actually take a new application from someone to be the successor guardian. And believe it or not, that happens quite a bit for various reasons, that we have to get a successor guardians through the program. And so not only does it cost the program money and time, but it costs practitioners money and time, and it costs the court a lot of time for having to reissue papers, have hearings for appointments, and most of it is fairly unnecessary, because it's just basically substituting a name of one person, you know, John Doe to Bob Doe or something like that. So you're still going to get overseen by the volunteer program. You're still going to be subject to all of their training and their requirements and their expertise. But we have to go through this paper shuffle to get the new person appointed. And so what this statute contemplates is allowing me as the court to name certain nonprofit corporations in the name of the corporation to be named as the guardian. Now there's one organization like that out here right now in Ohio. It's called APSE, and they are currently permitted to act as guardians of the person only, but they are limited to guardianships only for DD clients, for those with developmental disabilities. So anybody else, if it's a mental illness case, if it's just an old age case, if it's something other than developmental disabilities, APSE is not permitted to act as their guardian. And so for those DD cases, all I need to do is name APSE as the guardian, and APSE could, you know, plug in whoever they need to serve as the, de facto guardian, you know, the individual who's actually going to take charge of that person, of that ward. And so that's very beneficial because it saves the court and anybody else having to go through filing all these additional papers, asking to be a subsequent guardian appointed, and have another hearing, send notice out to those who need notice, and especially if it needs to happen quickly. Like we've had volunteers who become ill or passed away themselves, and if we need a guardian immediately, then it sometimes puts a burden on the process, on the system, to get someone else named. And so this, out of all the sections of this omnibus bill, this is the one I'm most excited to get started, because this will directly affect us here in Lake County. So just as APSI can get named, I could then name the VGP, we call it the Volunteer Guardian Program, as the official guardian, and then the program could appoint whomever their guardians or their staff members to serve as guardians. So those things are all going to be very important for us going forward, because as I stated, we get funding for the program through various entities, and eating up the costs in order to issue successor guardian papers is burdensome, and it's kind of a waste of some of the resources that we get from our generous donors, Lake Health and DD and Adams Board and things of that nature. So keeping our fingers crossed that this is going to pass this year and not have to start the process all over if we have to go into a new session. So I'm hoping that the lame duck session will be able to get this passed, especially since it was passed unanimously by the House. I don't anticipate anybody in the Senate having any issues with it. So we'll see how that goes. All right. So I apologize for going on and on about our volunteer program, but that's a big thing for us over here. All right, a couple other areas that may be changed with this omnibus probate bill. There's a change suggested in how an individual could make an anatomical gift. Right now, you could make an anatomical gift in a will or in some other document, some other planning document, a power of attorney, or anything withholding or granting or continuing life-sustaining treatment. You could say, mention something in there. So right now, this anticipated change may do away with that donation through the will and have it done other ways through some other paperwork, some other documents. So I don't know. I don't know what the value of that is, other than not having something like that in the will. But that's not too big of an issue for us here at the court at this point in time. I'm not sure. There are a bunch of changes to the Ohio Trust Code, and those are kind of numerous and detailed. So I'm not going to bore you with those, but just ask that you look at those. Those of you who handle trusts, there's a lot of information in this bill. And if it doesn't come to pass, if it does get changed, I don't want to spend a lot of time on that. Another area that may be changed that directly affects us here at the probate court is mental health civil commitments, and who the court is permitted to rely on to civilly commit somebody. Currently, it's got to be a licensed physician or a psychologist, psychiatrist, and what many communities are facing, especially these days, is that they don't have access to those type of healthcare providers in rural areas or in low population areas that they can call on to come in and testify at a hearing, because you got to have a hearing before we could civilly commit someone. And so sometimes these folks are getting let go from a pink slip without being able to get a civil commitment through the probate court. And so one of the things that this act is trying to allow is to authorize the probate court to consider testimony from other individuals, either a clinical nurse specialist who's certified as a psychiatric mental health clinical nurse specialist, or a certified nurse practitioner who's certified as a psychiatric mental health nurse practitioner by the American Nursing Credentialing Center. So right now, only the psychiatrist or licensed clinical psychologist can do it. And if these folks are able to, then we could have hearings in a timely basis, in a timely fashion, because as you know, on civil commitments, facility can only hold a person so long before they are entitled to have a hearing. And if they don't have a doctor available, then a lot of these people are getting turned loose on the streets, and they're harming themselves or harming others, and it creates quite a problem. So we're hoping that that's going to pass, so that it allows us a little more latitude to have these professionals who, face it, they work day to day with the mentally ill, and they're well versed in, diagnosing, sure, but treating and explaining to the court what the person's facing. And so I think it's a good bill to be supportive of, and hopefully that'll pass as well. Time is up. Oh my gosh! All right. I want to finish up with the trial, if I can, for a second, on our young Velma West. Anyhow, she was set for trial on March 6th. The prosecution and defense got together with the judge on March 5th to talk about the case. They all seemed to come to an agreement that the first-degree murder case wouldn't be able to be proven, so they agreed to a plea bargain on a second-degree murder. That took the death penalty off the table. She ended up going in that day, pleading, got sentenced right away to life in prison. At that time, parole eligibility was after 10 years. So she was hoping to get out in 10 years. In year 11 of her sentence, she was sent to Marysville. Same thing as up, nowadays. Went to Marysville. After 11 years, she was up for parole in 39. Her parole was denied. She was kind of despondent. Wasn't crazy about that. And so right around that time, she heard of 3 other inmates, fellow inmates, all young women as well, attempting to go Shawshank and break out of prison. So she asked if she could tag along, and they reluctantly let her. So on June 19th of 39, Velma broke out of prison with Mary Ellen Richards, 23, of Cincinnati, who was a cat burglar, Florence Sheline, 23, of Gallipolis, and Virginia Brody, 19, of Akron. So they somehow broke out of prison, I won't go into details, and got picked up in some truck. Before the prison officials even knew she was gone, they were already in Indiana. Ultimately, Velma and one of the others, I can't remember which one, ended up making their way down to Texas. And they were down in Texas living the high life. They were working at some bars. They were going out carousing. I think Velma even had a couple of marriage proposals thrown her way. And so they were out on the lam for about 40 days until some Dallas police officers saw their mugshots and their wanted posters or whatever, however they did it back then, and saw them in Dallas. They were walking across the street going out to dinner, and Dallas police saw them, grabbed them up, and Velma knew that the jig was up then. So they got transported back to Marysville. She had to do about a month or 2 in solitary confinement in Marysville. Her next shot at parole several years later was also denied. And then she ended up spending the rest of her years in Marysville. And she died, hold on a second, I'll finish up with that. She died in 59. She was about 53 years old, so she spent about 31 years of her life behind bars for hammering her husband, except for those 40 days that they were on the lam. So anyhow, thanks for your attention. I don't know how many of you were paying attention or doing work at your desk, but I think the one thing you learned from this seminar is that I definitely do not have a future in television. So thank you very much, and happy holidays.
Thanks so much, Judge. Great to have you back. And as with everybody, again, if people do have questions, please reach out to us, and we can connect you with the court and with the judge. Clearly, as Mark alluded to, there is a pivot in all things digital, whether it's on casework, it's the courts, it's the businesses, and that hopefully is something we've covered over the last couple days. The last thing I want to finish up with is something that will impact all of you personally and also for your clients. In June of this year, Regulation Best Interest was passed. This was the largest regulatory change since the Securities Act of 1934. And with this, a lot of it was missed because of everything that's been happening with COVID as far as June. There was a lawsuit filed to repeal this. And on June 29th, the Second Circuit Court of Appeals said that this was authorized by Dodd-Frank. It was not arbitrary or capricious, and therefore the rule would stand. And so we want to look at that. And then I also want to get into a little bit about types of relationships that you or your clients may have with advisors. The Reg BI changed the landscape for investment firms and the relationship that people have, because prior to this, the standard for the most part has been that, sorry, I'm getting a message here. Standard has been one of suitability as opposed to one of best interest. The suitability standard was something that various brokerage firms had to meet, whereas registered investment advisors have always had to meet a best interest standard. Suitability means you have to do what's suitable for the client, but not what's necessarily in their best interest. So, for example, the advice or the products might be suitable, but they may not be necessarily in the client's best interest. For example, if a firm was offering their own proprietary product and it was more expensive than something else, but suitable, then they could offer it. Regulation best interest said you could not do that. Everything that's being done had to be done in the client's best interest. And with that came a host of new rules, regulations, and disclosures. But essentially, all recommendations must be in the client's best interest. And interestingly enough, this includes not making changes to a portfolio, holding on to things. So this is much more of a principles-based rule as opposed to a prescriptive type rule. So there's 4 obligations. The first one is to disclose. The second one is care. The third is to avoid and identify conflicts of interest. And then obviously meeting all of the compliance rules. What the disclosure obligation says is that representatives must disclose all material information. And there's 2 new documents that all firms must provide to clients. The first is what's called a Form CRS, or Client Relationship Summary. And this is a 4-page summary that discusses both the services from a brokerage standpoint, advisory standpoint, that a firm might be provided. Reg BI disclosure is a more comprehensive document, excuse me, that has to be delivered to all clients and then updated periodically as time goes on. Now, the Form CRS requires disclosing the type and scope of services you're going to provide, what capacity the advisor is acting. And we're going to talk about this in a few minutes when we talk about the relationships you have. Are they working as a broker or registered representative, or are they providing advice? It also talks about the limitations of recommendations. It should disclose fees, costs, conflicts of interest, and then standards of conduct. It will disclose whether the firm or the professionals have reportable legal or disciplinary history. And then it's going to talk about how to get more information on the firm, and interestingly enough, what they call conversation starters, which are questions for the clients to ask of the representative from the form. Now, what's important is this delivery must happen before any recommendation is made. So a recommendation of an account type, a transaction, or an investment, it requires a documented proof that the firm delivered this to clients. So this created a lot of systems and administrative work that you had to be able to prove before you discussed really any investments that the client had received this form. Now, the standard of care obligation is that firms must have a reasonable basis for believing what they're offering is truly in the best interest of their clients. And they've got to be able to document that. So essentially, recommendations have to be in the best interest of a particular client based on that client's needs, objectives, risk profile, and what the investment offers in terms of potential reward or risk. Now, this also applies to a series of recommendations, so a course of action that the advisor is making. Key factors when we're looking at this are the advisor should be looking at the client's investment objective. Are there any special or unusual characteristics? What are their liquidity needs? What are the expected returns, volatility, and expenses on any recommendations? And then, very importantly, and something that's new, how did you look at reasonably available alternatives? Did you look at all the alternatives that a client may have invested in? So again, prior to this, firms often offered their own product. You had the Merrill Lynch fund, the Prudential fund, the Chase fund. Now you have to show not just that that investment is suitable, but that it's better than all the alternatives out there. And so this requires documentation, but it also means firms have had to take a hard look at what they're offering. Now, with conflicts of interest, it's interesting too, because this occurs at various levels. Firms must identify, mitigate, or eliminate, as well as disclose, conflicts of interest that could create an incentive for an investment to place their interest above the interest of the customer, so to offer something. And where this comes into play is many firms had sales contests. If you did so many accounts, you might have gotten a bonus, or if you sold one product versus another. Well, clearly, this prevents a potential conflict of interest. Obviously, one of the most famous examples of this is all of the Wells Fargo accounts that were opened. In many cases, people had no idea. Now, that's an extreme, but the Reg BI says we have to look at this and mitigate all conflicts. The other thing is that this would include potential conflicts at a firm level. So if an advisor works for a firm, is that firm receiving some incentive to offer a product or service that they may not otherwise offer without that enticement? Now, an important distinction, and we're going to get into this in a few minutes, is there are financial advisors that are employees of an investment firm, and therefore they're constrained by the products, services, and rules of that firm. There are other advisors in firms that are independent. So in our example, Carver Financial Services is an independent registered investment advisor. We don't have any products. We're not obligated or compelled to sell or do anything. We custody our accounts through Raymond James. We are not employees of Raymond James. If you are an employee or your advisor is an employee of a firm, again, there could be potential conflicts that would have to be disclosed and monitored. And then, of course, there's regular compliance obligations where firms have to develop policies and procedures as far as this goes. Now, it's interesting because the SEC had reviewed delaying the compliance date due to COVID-19, which was June 30th, but concluded that firms should be able to make good faith efforts around various operational matters. And so the rule did take effect and is in effect as of now. And as we said, the court case to overturn it was quashed by the Second Appellate Court. So this really is the law of the land. The other thing, and we touched on this briefly before, is that hold recommendations, telling a client to not do anything, is considered a recommendation. So somebody is explicitly telling a client to hold versus sell, that must be documented on a case-by-case basis. And the documentation must be retained, as well as showing that that hold is in fact in the client's best interest. So what we've seen is, to avoid conflicts of interest, many firms have adjusted their sales practices in the last few months. And even though vacated, most of the practices that have continued are similar to some of the ones that are being adopted. So, for example, C-share mutual funds that have no cost up front and no cost on the back, but do have higher internal expenses, will now convert to lower cost shares automatically, for example. Setting uniform commissions on products so that somebody's not incentivized to sell one versus another. Starting to standardize the classes of shares and eliminating higher cost products that are out there. The other thing that's becoming interesting is that some states are adopting their own standards. And this is causing some issues because in some cases, the state rules are actually tougher than the federal rules. And what we're trying to avoid, or what the regulators try to avoid, is some sort of a patchwork. So the SEC's rule seeks to be a model for a harmonized standard, if you will. And then again, they're trying to bring in some of the rules with regard to annuities and other types of securities. But again, something to stay tuned on, because as I say, some states are contemplating or have implemented their own fiduciary rules, which can cause problems from a regulatory standpoint. Massachusetts has issued very similar regulation to the one issued in New Jersey. And then the question becomes, where there's a conflict, does the state rule preempt the federal or not? And we're not sure. This could ultimately end up in the courts. The other problem with some of this is the fact that some individuals could lose access to investment advice. We saw some big changes along these lines made in the United Kingdom. And because of the cost, the potential liability, and the complexity of implementing, many brokerage firms simply dropped clients with assets less than certain amounts. We've already seen that with some firms in the United States that will not take on clients with less than $250,000 or $500,000, or they push them to a call center. And I think, and that's obviously been one of the industry arguments, is that if you become too draconian with the rules, regulations, requirements, we're simply not going to take on small clients. We're just going to focus on larger clients where the risk to return makes sense from a business standpoint. So, kind of to summarize, Reg BI is really defined by 4 obligations: disclosure, care, conflicts of interest, and compliance. And it's trying to generate a standard of care beyond the suitability standard that we've worked with over the years to a true best interest standard. Now, this applies to all recommendations, and we're going to talk in a minute how an attorney or a CPA could now become a fiduciary and have that potential liability under this regulation, because it applies to all recommendations, including holds and rollovers. So, different advisory relationships have different compensation. As you speak to advisors, one of the things is to understand, and again, whether this is representing a client or representing yourself personally, is what role does the advisor and the firm you're speaking to provide? It used to be you had brokerage firms that basically brokered investments, and their only guidance was a suitability standard. You had financial planners who did holistic planning, perhaps for a fee, but did not sell investments. And you had people that might have done both. The other thing is pretty much everybody was calling themselves a financial advisor, or in some cases financial planner, when they may not have been. They may have been doing simply investment management, selling investments, or they may have been doing holistic planning. Many independent advisory firms, such as ours, we do holistic planning, but we also handle the investment, brokerage, and custody of assets. And then, of course, a key question is, how are they being compensated for their services? So the two broad compensation models are fee-based and commission-based. Commission-based being where someone's paid for a transaction. In fee-based, somebody's typically being paid a percentage of the assets they manage, a flat fee, or sometimes hourly. It is not allowed for an investment advisor, other than the case of hedge funds, to participate in gains or losses. So I often ask, can you just, take a percentage? From our standpoint, we believe that a flat fee based on assets is the best arrangement for minimizing conflicts of interest and aligning interests between the advisor and the clients, because there are no costs up front, there are no costs on the back end, there are no transaction fees, so there's no incentive to buy or sell. As the assets grow, the advisor and their firm will make more money because they're getting a percentage of the assets. Conversely, if the assets go down, the advisor makes less, or the client becomes disgruntled and goes someplace else. In a firm like ours, where there's no proprietary investments, people can, pick up their toys and leave at any time. The only incentive for someone to stay is because they're happy. And so generally speaking, we would recommend a fee-based arrangement. And in the case where you are a fiduciary, in terms of being a guardian or a trustee, that's going to be very important to eliminate potential conflicts of interest, and also to document what you're doing for the courts as far as that goes. Different advisory relationships and compensation bring up different questions. So the first one is the advisor in the firm acting as a fiduciary, or are they merely acting as an agent? Is the account discretionary? In other words, can they make decisions and do transactions without asking you ahead of time? If it is, do they use some standard model? Do they offer just proprietary funds, or do they offer custom allocated scenarios? More and more, we see firms using standard models where all clients get the same thing. And this may not be in the best interest, because often it does not take into account tax consequences. At the end of the day, what the client makes is not important. What the client keeps is vital. It's not what you make, it's what you keep after fees, expenses, taxes. And so it's important to take a very proactive tax view, which again, a lot of people do not. The other thing is simply looking at percentage returns often does not tell the story. In fact, from our standpoint, minimizing volatility and minimizing loss is much more important than having huge returns. Give you an example. If a client bought an investment and they went up 100%, and then the next year they went down just 50%, you'd think they made some money. And actually, their average return is 25% per year. Plus 100 minus 50 is 50, divided by 2, 25% per year. The fact is, though, they made nothing. So if a client had $1 million and they made 100%, they went to $2 million. If they then lost 50%, they went right back to $1 million. They didn't make anything. And in fact, they may have lost because they may have paid fees or taxes along the way. And so even though the track record there is 25% per year, no money was made because of the extreme volatility. And so it's very important when looking at some of these, especially these standard models, to look beyond the numbers and work with an advisor that can certainly explain that. Now, the other question is, where are the assets held and who's reporting? Obviously, with the Bernie Madoff case, the reporting was falsified and there were no assets. So if you work with an advisor, where are the assets custodied? In our case, we're an independent registered investment advisor, but all of our client assets are held at Raymond James. They're insured through Raymond James, and equally important, the reporting is direct from Raymond James. So they're getting independent third-party reporting. Anytime that you're working with an advisor, particularly if you're in a fiduciary position, you need to have that independent third-party reporting. And then the question is, are the statements provided suitable for the court? So the statements we provide are principal and interest accounting. They show cost basis. The courts will accept those. And then what type of account insurance is provided? How are the assets protected if there's a data breach or if there's a problem with somebody at the firm? And lastly, what is the strength of the firm? If you're dealing with just an individual, even at a major firm, what's the business continuity plan? What if that person dies? What will happen? So it's important to understand, even if you're with a larger firm, what's the plan? In our case, we have documented succession plans. We also have business continuity plans and data security plans that we can share. So in the event of a natural disaster or something happens, how available are the people you're working with for your clients? Now, a key question, because it can raise potential liability for you, the attorney or the CPA, is, are you a fiduciary? And typically this is a person, organization that owes a duty of good faith and trust to another. But the landscape has changed. If we look at ERISA, which applies to retirement plans and is monitored through the Department of Labor, traditionally attorneys and CPAs were not considered fiduciaries. Because under ERISA, a person's considered a fiduciary if he or she, quote, renders investment advice for a fee or other compensation, or has the authority or responsibility to do so. But with the Department of Labor fiduciary definition, the advice relationship changes, because now a fiduciary is anybody that holds themselves out to be a fiduciary, who provides advice, or that the recipient believes is advice based on their needs. So even if you don't provide advice, if your client thinks you did, you could be considered a fiduciary and held liable for any actions that result from actions your client takes. That's very significant. In a casual conversation, you talk about rolling over a 401k plan. If you're doing an estate plan and you talk about holding an asset or step up in basis, you could now be a fiduciary. Other changes, as we say, if the client believes you're giving advice, you are. And it's no longer just ongoing or regular. nor is it even limited to investments. As we said, it could be just talk about rolling over a retirement plan, or talk about IRAs, converting to a Roth IRA, for example. Should somebody convert or not convert? That's a conversation CPAs have every day, because you're discussing, should the client pay tax? Shouldn't they? What are the implications? And now you could be inadvertently brought in as a fiduciary. So according to the AICPA, again, DOL typically exempts accountants that have not been treated as ERISA fiduciaries. However, when accountants make recommendations on retirement accounts, both qualified plans and IRAs, with regard to rollovers, transfers, distributions, conversions, then they will be considered a fiduciary. And you definitely need to be aware of that. So this is one of the reasons you should think a lot about whether you want to be named as a guardian or a trustee, because there is a higher level of potential fiduciary liability associated with that formalized role than might otherwise be the case. So, documentation on your part is critical in discussing why you retained the advisor you chose to work with, what your screening process was, what criteria you had, and what your due diligence was. For the advisor, the questions to ask are, how do you arrive at your recommendations? What's the process? What other options were considered, and why did you choose what you did versus what they were? What were the costs and the compensation you receive on all considered solutions? What's your process to do ongoing reviews if we execute the recommendation? And why did you or didn't you recommend other changes? And finally, how are you going to communicate this with me or the client? What's your process for doing so with statements or other regular communication, such as reviews or newsletters or customized letters? From my standpoint, having done this for 34 years, I think it's critical that there are ongoing conversations with the clients. Investments and portfolios are not a means unto themselves. They're means to an end. People typically don't invest just for the sake of investing. They're investing to accomplish something, whether it's maintaining their lifestyle, supporting somebody else, paying for education, or passing assets on to their heirs. That's why they're doing what they do. And the better the understanding that you, as a trusted advisor, fiduciary, perhaps, have, the more relevant the advice you can give, and the more compliant you can be. As litigious as everything is, documenting all of this is just very, very critical. Now, if we look at ERISA, I mention it because it serves as a great guide if you are going to be a guardian or a trustee. The first thing that ERISA says is investment policy statements should be in writing. It doesn't say they must be. And this is a trap, because the first thing that's going to happen if you or your client is audited by the Department of Labor, if they walk in, it's going to say, can we see your investment policy statement? It's not required, but it is the standard they're going to judge everything against. And if you don't have one, then it's going to be much harder to support whatever actions you took. I have seen clients that have had huge problems with their investments, that there's been bad decisions, there's been losses, and the fact that they could justify the actions they took via their policy statement, they were fine. On the other hand, I've seen clients that have had phenomenal returns. A disgruntled employee goes to the Department of Labor, makes a complaint, and consequently they've been fined or had other tax issues because they could not document what they did. It's not about what happened. It's about what you can document. In the case of a guardianship, in the case of a trust, where you are working for a nonprofit, the first thing to do is to develop an investment policy statement. This is something we have templates we can provide, and we're happy to help without cost or obligation to develop this. The second thing is investment decisions must be made against a prudent expert standard. In Ohio and a number of places, the standard previously was a prudent man, the so-called prudent man rule. What would a prudent man do? But now it's a prudent expert. So for example, if somebody has a trust account for young children and they put it all in certificates of deposit, you could argue that's what a prudent man would do because we don't want to lose the money. The problem is no prudent expert would do that. There was actually a very interesting case in Lorain County where two minor children, once they reached the age of majority, sued a bank trust company because the bank had kept the majority of the assets in CDs and treasury bills and missed the huge bull market that occurred in the 90s. And of course, hindsight being 2020, the children and their lawyer said, hey, if we had been invested as an expert and no expert would have just put money in cash, we would have made 2 or 3 times as much. And they won. And the bank had to make up the difference. Today, if you are a fiduciary or you're the trustee, you could be held liable. And by the way, in the case of ERISA, you are personally liable for fines. A corporate entity is not necessarily going to protect you. So it's good to work with an expert, not only to take the emotions out of it, but to understand that a proper asset allocation today might have very little in cash or certificates of deposit, might be heavily weighted towards equities. It might own things like real estate or international holdings or emerging markets. And so, again, looking at those decisions through the eyes of an expert and then documenting why you did what you did in meeting your policy statement. Plan assets must be diversified. That's both as to type and to class. So having all of your money in a large cap mutual fund or mutual funds is not diversified. Having funds that buy international and domestic, small companies and large, having some money in fixed income, that would be more diversified. And that's where, again, that expert standard will come in. Plan investment performance must be monitored. As we just did with our little example, just look at the numbers doesn't tell the story. Again, in our example, the portfolio made 25% per year, and you have the same or less money than you started with. You've got to understand what the performance really is, and then document how you're monitoring that. Obviously, prohibited transactions must be avoided. That implies we know what's prohibited. And finally, duties must be discharged for the exclusive purpose of providing benefits to the participants and to defray reasonable administrative expense. This is a very interesting one because ERISA and really anywhere that we look at regulations does not say you must buy the least expensive investment. It does say you have to make a reasonable effort to look at the expense and justify them. So typically there are 3 expenses that we need to consider. There are the administrative expenses, if any. There are the internal expenses to any investment. A mutual fund or index will have expense. And then there are the advisory fees that you or the advisor may be charging. And clearly, that's something that's easy enough to benchmark and should be fully disclosed. The internal expenses are a little trickier. And so, if you have 2 investments, they both buy the same types of things, and there are different internal expenses, why did you go with A versus B? And this again comes back to Reg BI that says the advisor must look at all reasonable alternatives and must justify why they selected what they did. It doesn't necessarily have to be the least expensive, but it does have to be documented how you came to the decision, and that's really the best one for the client at the end of the day. All of this, if we could flip the slide real quick, please. All of this comes down to evaluating what's best for the client. So, first of all, understanding the type of relationship both that you have with your client, are you a fiduciary, are you not? And then more significantly, understanding the relationship of the financial advisor or firm. Are they a fiduciary or aren't they? How are they charging? Are they simply an investment broker? Are they a money manager, or are they providing comprehensive planning? I would suggest to you that it's very difficult to do the first two without doing the planning. And so it's important to work with a firm or advisor that truly takes a holistic approach. And while everybody can say they're a financial planner, looking for a certified financial planner, looking at the credentials is very, very important. We need to look at the expense, which implies we understand what the expenses are, the advisory expense, the brokerage expense, and any other fees. We're starting to see some firms charge retainers or planning fees. On the other hand, we're seeing a race to the bottom. There are several firms that are offering investments with zero internal expense, kind of as a loss leader to get people to come in and utilize other services. Understanding what the reporting and the documentation is, and is this the best for your client? Is it virtual? Is it hard copy? Is it suitable for the courts if that's an issue? And how often do you get it? How accessible is it? And finally, what is the monitoring and feedback mechanism from the folks you're working with? How often do they meet with you? We believe that a comprehensive planning meeting is needed at least twice a year, and in some cases could be as often as every 2 to 3 months, because things change from a client standpoint, things change from a regulatory standpoint, and things change from an economic standpoint. Quite frankly, doing a financial plan that's printed, I think, is almost a waste of time if it's a one-time event. It's outdated as soon as it's done. Financial planning needs to be a dynamic process where the plan is updated and changed based on changing needs for the client and given circumstances. Slide, please. So, with all of that, I absolutely want to thank everybody. If you have questions for myself or any of our other speakers, please feel free to reach out to me. I sincerely hope you take a few minutes with our survey so you can provide feedback on what we can do better, what we can provide to you going forward. It's just unbelievable to think we've been doing this for 33, now going on 34 years. And we certainly, as time changes, appreciate everybody that's joining us, because it does show that besides wanting some CLEs, and I think at some point we're called the Earl Scheib of CLE, given our pricing, but it does show a degree of professionalism as you seek to stay up to date on topics that are important, and that's what we want to provide to all of you. So if there's anything that I can do or my team can do, please feel free to reach out to me personally. Keep an eye out for an email from Kelly Drum with the survey and also the attestation that you joined us today. We will be having a number of virtual events coming up, which you're all welcome to attend. They're listed on our website under events. We've also done a couple things in the last few months that may be of interest, including a recent interview with Kevin O'Leary from Shark Tank. The next event that we'll be doing is January 9th with Paul Riley, the chairman and CEO of Raymond James, and we'll be discussing more of the regulatory landscape. As we spoke about yesterday, on January 5th, we'll know the outcome of the Georgia Senate runoff race. This is a critical race because it's going to dictate the tone of the government for at least the next 2 years, if not the next 4 years, based on the outcome. And so we'll be discussing that on the 9th after we know where we're going. I hope that everyone's enjoyed the last couple of days. I absolutely want to thank all of our speakers for taking time out of their schedules, not just today, but with all the preparation. And finally, I do want to thank Scott and Jeff from Podworks, who made this happen at 3 a.m. their time. So have a wonderful day, and thank you so much.